You are filing a CRPIO review against an order passed by this court. Why? For what do you want the listing? What do you want the listing for? Why? Hearing. Huh? Why? You don't know, don't mention. Next. You have filed it. You want to bring it. Let us stay. Okay. Other side is not appearing. Heard Mr. A. Ahmed, the learned counsel appearing on behalf of the petitioner, who submits that he has instructions to withdraw the instant petition. Accordingly, the instant petition stands closed on withdrawal. The interim order passed earlier, staying the proceedings before the court of the it can't be. Can't be. Learned Munsif Bongaigaon, Learned Court of the Munsif Bongaigaon is hereby vacated, and the parties are directed to appear before the Learned Trial Court on 6th of June 2025. Silable, order to silable. Huh? Number one. Next. Early hearing. Okay. We'll have it on 30. Huh? Civil revision. IO for 4th of June.
For motion item 1.
Why does she have to travel? So, understood, a lawyer will appear, these are suits. So what? Here also, who is going to appear? Who will appear here? Who will appear here in Guwahati if I transfer it? It is not in a family court. How? This is not a dissolution of marriage. This is a Muslim dissolution of marriage. So it will be a suit. It's a regular suit. So then why in Guwahati, what is the benefit you get? How? How can you appear? So do you give an undertaking that you won't engage a lawyer if it is being transferred here? It is not a family court. This suit cannot go in a family court. This is not a family court. It's a pure suit for dissolution of a Muslim marriage, which is different. It cannot equate it to any other suit. Then Sri Bhumi is better. You have to engage a lawyer. That's all. For that, you file maintenance application. And the suit is proceeding ex parte against them. Where is the order of vacating? No, where you have engaged all other orders, not this order. Why? Then your statement would not, if you can enclose all other orders, why not this order? You have enclosed all orders. Then go and appear before that court. No case. No case, Mr. Counsel, no case. You place whatever may be, but then also no case. Notice, no notice. Have you filed your written statement there or not? Go and file your written statement. So how does it matter? So the next date is fixed. Next date is fixed on Wednesday. You want to stay? No. This is a case for dismissal right away. Hindu is different. Hindu is different. Can't help it. Hindu is before the courts. It is under the Hindu Marriage Act, then it is before the district judge. Because there you have to appear in person. Here you don't have to. Because this is a normal suit. You'll engage a lawyer. So what? You could go there and file an application. Go there. File your written statement. No stay. Stay notice is not there. No case. Why should I say anything about maintenance? Go there, file an application for maintenance. Oh, very well. You'll get it. So what? No, no, no. File your return statement. You want an adjournment today? It will again come. You should have moved it last week. I'm dismissing it right away. It's not the case. Yeah, this is a pure simple suit. Simple suit, what is your problem? Huh? Your parents stay there. Go there. You are the only case which I have where the parents are not taking help. Anyways, what do you want? Dismissal or time? Dismissal. Which one do you want? You have your parents there. Go there. How are you bearing? Not your parents. But the parents have not allowed you to stay there. Where? Why you staying in a rented house? Go there. Stay in your parents. Sribhumi place is cheaper than Guwahati. Which one do you want? Dismissal or time? Time. Counsel appearing on behalf of the petitioner seeks for accommodation. List the matter next week.
Item 2,
What? Page? Yes. Then what happened? What are you challenging, Mr. Sayula? What are you challenging? One? 20. Now let's see the decree passed by this court. Page. So you are the decree holders are tenant as well as the year. So you have a right over the Schedule 4 land. Now what has happened? Where your execution petition? Page. Who is the plaintiff number 2? Plaintiff number 3? Three is Lalchan. So Lalchan has 50% right as a tenant. And plaintiff number 1 has 50%. Now what is the decree you are asking for? Schedule 4 land. Described by evicting the demolishing the structures standing on the yard to deliver possession and to decree of the Yes. How can it be dismissed? No. The trial court, the second appellate court passed an order that 50% should go to the plaintiff number 1 and 50% as a tenant will go to the plaintiff number 3. No, that I am not concerned. That is not for the court to decide. The court said that executing court has to say, then if the landlord wants to come out there and say anything, it will be another petition. I'm not on that. But how can the application be dismissed under 47? Who filed the 47? Who are you? So you are the judgment debtor. So the question is, how can the entire execution proceedings be dismissed? Whether they file it or not, isn't it the executing court's duty to see to it that the decree is executed? I'm not concerned with that. Mr. Counsel, kindly appreciate one thing. If the applicant, here it is being sought for, if you see the execution application, it is categorically mentioned out there that they only want as regards the Schedule 4. Schedule 4, 50% has been given to the plaintiff number 1 and 2. And 50% has been given the other, and the word used is the other 50% to the plaintiff number 3. Whatever may be, as tenant. So other 50%, the word used is other 50%. Now, if you see the execution application, what do they say out here? Categorically see that. What is they asking? Kindly see the mode of assistance, page 77. The decree holder pays for recovery or possession of the Schedule 4 land described herein after by evicting the defendants and demolishing the structures in the 4th Schedule land. Now, if the 4th Schedule land, 50% has been given to the plaintiff number 1 and 2, and 50% as tenant has been given to the defendant plaintiff number 3, that is 100%. So the entire Schedule 4 has to be taken. While the earlier, you have challenged before this court and you have categorically said that you had no objection in respect to the execution of Schedule 4, but it should not be done in Schedule 3. Now the court's duty is to see to it that the execution is done in Schedule 4 and not to dismiss the execution application. Are you appearing for all? Okay. Who filed the application under Section 47? So what are you doing? You have not filed, you have no objection. We dispose it of. This is absolutely in violation of this. Go to Supreme Court. This is not a case. No, nothing. No, enough. Enough is enough. No. No. I'm not going to look into all these things. This is absolute case of what is wrong with these courts. It is for the executing court to do it. For that, you make a submission before the Supreme Court. Heard Mr. G.N. Sahewala, the learned counsel, appearing on behalf of the petition, assisted by Ms. S. Todi. Mr. B.K. Sen, take your seat. And Mr. B.K. Sen, who appears on behalf of the respondent number 2. Full stop. The manner in which the learned executing court is proceeding in the execution of execution case number 1 of 2016 shocks this court. And as such, the instant order is being passed at the stage of motion itself. Full stop. It is seen from the materials on record that the coordinate bench of this court in RSA number 7/2001 decreed the suit in favor of the plaintiffs insofar as Schedule 4 is concerned. Paragraph 20 of the said judgment passed by this court dated 15/5/2012 is reproduced hereunder. Page 74. Paragraph 20, no? Paragraph 20 of the judgment passed by this court dated 15/5/2012 in RAC number 7/2001 is quoted hereunder. From a perusal of the above judgment, above quoted portion, it would be seen that the coordinate bench of this court, while affirming the judgment and decree passed by the learned First Appellate Court in title appeal number 37/1998, declared that the plaintiff number one's right in respect of 50% of the Schedule 4 land and the plaintiff number three's status as tenant in respect of the remaining 50% of the Schedule 4 land, as well as eviction of the defendants from 50% of the land in Schedule 4. The learned trial court, learned coordinate bench further passed the order that the decree, the learned coordinate bench of this court further observed that the declaration so made in favor of the plaintiff number 1 and 2 in respect of the Schedule 3 land was set aside. It is seen that pursuant thereto, a title execution case number 1/2016 was filed. Huh? Was filed, wherein the decree holders prayed for recovery of khas possession of the Schedule 4 land described therein by evicting the judgment debtors / defendants, and also for demolishing the structures, houses made in the 4th scheduled land, and to deliver possession of the 4th scheduled land to the decree holder / plaintiff by the court. Footstep. Subsequent to the filing of the said proceedings, an application was filed by the judgment debtors, stating inter alia that the decree is not executable. Full stop. By an order dated 8/7/2019, the said application was rejected and a writ of possession was directed to be issued. Was issued in favor of the civil nazir for execution of the decree. Challenging the said order dated 8/7/2019, A proceedings was filed by the decree holders, a judgment debtors, which was registered and numbered as CRPIO number 231/2019. In the said proceedings, the judgment debtors, the counsel who represented the judgment debtors, submitted that they had no objection, that the judgment debtors had no objection insofar as the execution of the decree in respect to Schedule 4 property is concerned. And if it is done within the parameters of the Schedule 4 property as described in the schedule execution application. The only objection which was put before this court was that the executing court, while delivering the possession of the Schedule 4 property, should not deliver the Schedule 3 property in respect to which there is no decree for delivery of possession. This court, by an order dated 29/11/2021 in CRPIO 231/2019, did not interfere with the order dated 8/7/2019 passed by the learned executing court, and further observed that the learned executing court, while issuing the writ of possession, shall direct the civil nazir to execute and deliver the possession of the Schedule 4 property to the decree holders in accordance with the boundaries as mentioned in Schedule 4 of the execution application. Subsequent thereto, the learned executing court, for reasons best known, had issued a writ for delivery of possession of all the schedules to the plaintiff, that is Schedule 1, Schedule 2, and Schedule 2, Schedule 3, and Schedule 4. Although the judgment and decree which have been passed by the coordinate bench of this court was only in respect to the Schedule 4 property, and more particularly as regards 50% of the said property of the Schedule 4. Under such circumstances, an application was filed under Section 47 by the judgment debtors, which was registered as Ms. J case number 294/2025. The decree holders filed an objection to the said petition filed under Section 47. And further admitted that the delivery of possession would have been only in respect to the Schedule 4 property. However, to the utter astonishment of this court, the learned executing court, by an order dated 29/4/2025, dismissed the entire execution proceedings. And it is under such circumstances the present proceedings have been filed. Next. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. Taking into account that the impugn order is passed in a proceedings filed by the respondent number 2, who is the caveator, in the opinion of this court, The question of issuance of notice to the respondent number one does not arise. Show me who has filed. Both have filed. You have, Mr. Sen, kindly don't try to mislead this court. Kindly come to page 98. And who has signed this? Verification is done by whom? Page 113. Who has done it? And he is the person who has done the verification? Page 113. Absolutely no. Not necessary. For that, go to Supreme Court. I'm not bothered. Mr. Sen, take your seat. No, no point. No point, Mr. Sen, kindly take your seat. No point. No. Let me dictate the order, then whatever you do. Absolutely, Mr. Sen, I am not going to pass any order to that effect. Yes. Mr. Sen, take your seat. Enough. Mr. Sen, take your seat. Okay, I have understood. Mr. Sen, I have understood. Take your seat. I've heard the learned counsels appearing on the air. It is seen from the judgment and decree passed by the coordinate bench of the court, dated 15/5/2012 in RSC number 7/2001, that the plaintiff number one's right in respect of 50% of the Schedule A land, 4 land, and the plaintiff number three's status as tenant in respect of the remaining 50% of the Schedule 4 land, as well as eviction of the defendants from 50% of the land in Schedule 4 was decreed. First. Therefore, there is an executable decree insofar as 50% of the Schedule 4 land Full stop. Under such circumstances, the learned executing court could not have dismissed the execution application. Full stop. Now let this court take note of the submission of Mr. B.K. Sen, the learned counsel who represents the judgment debtors, who submits that the 50% of the decreed land in Schedule 4 is not identifiable. And as such, the learned executing court was justified in dismissing the said application. First, the said submission so made is totally misconceived, taking into account that the power under Section 47 upon the learned executing court is not only to execute the decree, but also deal with all questions relating to discharge and satisfaction of the decree. Full stop. If the schedule 50% of the Schedule 4 land is which have been directed to be in a full stop. The executable decree so passed by the learned court in a bench of this court being 50% of the Schedule 4 land. It is therefore the bounden duty of the learned executing court to find out and identify the area and thereupon deliver the possession, and not to dismiss the entire execution application on mere technicality. It is a settled position of law that the executing court has to take effective steps so that the fruits of the decree can be enjoyed by the decree holder. Under such circumstances, this court interferes with the order passed by the learned executing court dated 29/4/2025, passed in Ms. J case number 294/2025, arising out of title execution case number 1/2016, and restores the title execution case number 1/2016 to the file of the learned executing court, that is the court of the learned civil judge, junior division number 1, Sri Bhumi, and further directs the learned executing court to carry out the decree, to execute the decree in the manner aforementioned, as well as taking into account paragraph number 20 of the judgment and decree passed by this court in RSA number 7/2001. Full stop. With the above, the instant proceeding stands disposed. Allowed. No clarification. You have lost your chance of clarification. Identify it. There is no boundaries mentioned in the decree. In the judgment, there is no mention of a boundary. 50% of Schedule 4. I am not concerned. Schedule 4, they will identify and do it. Remaining is for Supreme Court to do. Next.
3.
Same judgment. So here 1 poor 4 justi 5 gondas is being decreed. Then what has happened? Ah. According this court therefore directs the executing court to go ahead with the execution proceedings in title execution case number 2 of strictly in terms with the decree passed by the court. That is in respect of 1 poor 4 justi 5 pawns 5 gondas. How much it is being given? Why was 5 pawns and 5 gondas coming? Huh? What was the decree passed? 1 poor 4 justi 5 gondas. And why does the 5 pawns come also? That is wrong. Then, and that is the area which is there in Schedule 1. Schedule 2 is a part of Schedule 1. And what is the area of the Schedule 2? Within the boundary of Iman and in favor of the plaintiff is 1 poor 4 justi 5 pond and 5 gondas. So there, this is wrong. But this is the decree which is signed. Huh? Page? No, 61A. In view of both the courts below have rightly decreed the suit of the plaintiff number declaring the landholder's right in respect of the Schedule 1 land, that is 1 4 justi 5 pond 5 gondas. The decree for recovery of in respect to the said land has been rightly passed. So this is 1 poor 4 justi. So this is Schedule 1 land. No, but Schedule 2, there is nothing mentioned. There is no area mentioned. What is given is this Schedule 1, page 97. Then and here also dismissed. Goodness, what is wrong with the judge? And what is the reason given here? Goodness, see this, page 125. On perusal of the documents filed by the judgment and defendants, it appears the Honorable High Court, as per the judgment and decree dated past in remand, did not pass any decree in favor of remand in respect to the scheduled land of the plain other than 1 poor 4 justi 5 pond and 5 gondas in schedule area. Accordingly, it appears that a warrant of possession dated so and so issued by the bailiff of this court to give possession of schedule 1 to the area is beyond the decree of the past by, and accordingly the way is set aside. The warrant of possession dated issued by the bailiff to give possession of the land described in Schedule 1 and 2 described in the EI is accordingly recalled, and title execution instituted by the decree holder is hereby dismissed. This is wrong. Heard Mr. J.N. Sahewala, the learned senior counsel, assisted by Mr. S.O.D., Mr. B.K. Sen, who appears on behalf of the aviator. Very well. If it is, that is, they are to find out. I'll put it that to be a submission out there. But what is the reason assigned? How can the execution proceedings be dismissed? It may say that it has been satisfied. It cannot be dismissed. Meaning thereby, when they are still executing it, the court has to say that it has been duly satisfied because they are in possession. But without doing this, what it is this type of order? It seems that it is an after effect of the 6 months period to dispose of the execution proceedings as mandated by the Supreme Court. This seems to be the reason. Why should I go further? Let me dismiss it. That seems to be a... Now, when he categorically says that Schedule 2 was not given, this area was given, then he should have said that it has been duly satisfied because they are already in possession and then close it. But if it is not so, how can you dismiss it? It's never heard of. And Mr. So-and-so, who appears on behalf of the respondent numbers, respondent number 2 on caveat. The manner in which the learned court of the Civil Judge Junior Division number 1 Sribhumi, hereinafter referred to as the learned trial court, executing court, have proceeded with the execution and dismissed the execution proceeding. This court takes up the instant proceedings for disposal at the stage of motion itself. Taking into account that the respondent numbers 1, 2, and 3 had jointly filed an application under Section 47, and the said application was filed on the basis of an affidavit filed by the respondent number 2, this court does not fit the necessity of issuance of notice, as the same would only delay the execution proceedings. Because a paragraph to body. The materials on record shows that the coordinate bench of this court in RSA number 8/2001, by the judgment and order dated 17/5/2012, confirmed the judgment and decree passed by the learned Civil Judge Senior Division Karimganj in title appeal number 36/1998. However, in doing so, there certain modifications were made, as would be seen from paragraph number 17 of the judgment and order dated 17/5/2012 of the coordinate bench of this court, of the learned coordinate bench of this court. Paragraph 17 of the said judgment is reproduced hereunder. From the above, from a perusal of the above quoted portion of the judgment and order passed by the learned coordinate bench, it is seen that the learned coordinate bench had held that the courts below had rightly decreed the suit of the plaintiff number 2 to 4, declaring landholders' right in respect of the part of the Schedule 1, that is, 1 poor, 4 justi, 5 pawn, 5 gondas of land. And further held that a decree for recovery of khas possession in respect of the said land had also rightly been passed. The learned coordinate bench further held that insofar as the judgment and decree passed by the learned courts below, declaring the plaintiff number one's tenancy right over the Schedule 1 land, apart from the decree passed for recovery of khas possession in respect of the land other than the land measuring 1 poor, 4 justi, 5 pawn, and 5 gondas was set aside. Pursuant thereto, an execution proceedings was filed before the learned executing court, which was registered and numbered as title execution case number 2/16, 2016, wherein execution was sought for recovery of khas possession of the land described of the described in Schedule 2 to the Schedule 2. Pursuant to the said execution application being filed, the degree judgment debtors filed the judgment debtors filed number 3 and 4 filed an application being Miss Case number 164/2016. Taking rejection of seeking setting aside of the judgment and decree passed in title suit number 293/1993, both by the learned trial court as well as the honorable appellate courts, on the ground and circumstances set forth therein, and dismiss the title execution case number 2/2016. This application, so filed by the judgment debtors, more particularly judgment debtors number 3 and 4, was dismissed by an order dated 14/2/2020. And it is under such circumstances, being aggrieved, all the judgment debtors joined together to file an application under Article 2 to 7 of the Constitution, challenging the order dated 14/2/2016, passed in title execution case number 2/2016, as well as Miss case number 164/2016. This court, by an order dated 27/2022, disposed of the said proceedings the categorical direction upon the learned executing court to go ahead with the execution proceedings in title execution case number 2/2016 strictly in terms with the decree passed by this court. That is in respect of 1 Poa 4 Justi 5.5 Gondas, which is a part of the Schedule 1 land in terms with the order dated 14/2/2020 passed in title execution case number so and locating the boundary as directed in the order dated 14/2/2020. Paragraph number 8 to 11 being relevant is reproduced here in under. It is relevant to take note of that there was no challenge to the said order passed by this court. Order passed by this court dated 27/2022 in CRP IO number 58/2020, and as such, the same had attained finality. Next. Be that as it may, the learned executing court, in spite of specific directions being passed by this court, in the above quoted paragraphs of its order dated 27/2022, issued a writ for delivery of possession in respect to both the Schedule 1 and the Schedule 2 land. The issuance of the said writ for delivery of possession was completely contrary not only to the judgment and decree passed by the coordinate bench of this court dated 17/5/2012 in RSA number 8/2001, but also to the directions passed by this court in the order dated 27/2022. The judgment debtors thereupon filed an application under section 47 before the learned executing court which was registered and numbered as means the case number 295/2025. The learned the judgment debtors, the respondent, the judgment debtors, more particularly the respondent number 2, herein sought for recall of the writ for delivery of possession dated 12/3/2023, as well as sought for dismissal of the execution proceedings being title execution case number 2/2016. The learned trial court, the decree holders filed the objections to the said application. And by drawing the attention of the learned executing court to the order passed by this court dated 27/2022 in CRP IO number 158/2020. Most surprisingly, while in order dated 29/4/2025, the learned executing court dismissed the execution proceedings and as such the present proceedings. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the judgment and decree passed by the coordinate bench of this court, dated 17/5/2012 in RSA number 8/2001, it is apparent that there is an executable decree insofar as a plot of land at measuring 1 poa, 4 justi, 5 pon, 5 gondas, which is a part of the Schedule 1 land. Full stop. This aspect of the matter was clarified by the court, was further retreated by the court in the order dated 27/2022 in CRP IO number 158/2020. Full stop. In spite of that, the learned executing court had erroneously issued a writ for delivery or possession of Schedule 1 and Schedule 2 land without properly ascertaining the directions passed by this court in the judgment and decree dated 17/5/2012, as well as the order in RAC number 8/2001, as well as the order dated 27/2022, passed in CRP IO number 58/2020. First, in the opinion of the court, the order dated, impugned order dated 29/4/2025, insofar as recalling the writ for delivery of possession, dated 22, what is the date? Dated 12/3/2023, was in accordance with law, taking into account that the writ which was issued was not in consonance with the judgment and decree passed by the learned coordinate bench of this court, as well as the order passed by this court dated 27/2022. But it shocks and surprises this court as to why the learned executing court had dismissed the title execution case number 2/2016. First, Mr. B.K. Sen, the learned counsel appearing on behalf of the judgment debtor, submits that the land which is there, which was decreed, is already in possession of the decree holders, and as such, the decree was no longer executable. First, if that be so, in the opinion of this court, if the submission so made by Mr. B.K. Sen, the learned counsel appearing on behalf of the judgment debtor, is accepted to be true, then also it may be a case of satisfaction but not a dismissal of the execution proceedings. Full stop. Further to that, there is no order passed. Further to that, the impugned order does not mention that the judgment debtors, the petitioner hearing, decree holders, the petitioner hearing, are in possession of the decreed land. Full stop. Under such circumstances, this court interferes with the order dated 29, impugned order dated 29/4/2025, passed in Ms. J case number 295/2025, insofar as dismissal of the execution application, being execution case, title execution case number 2/2016. Full stop. This court further disposes of the instant proceedings with the following observations and directions. Number one, the title execution case number 2/2016 is restored to the file of the learned executing court. Full stop. Number two, the learned executing court shall ensure that the decree the decree so passed in RSA number 8/2001 is executed. Full stop. Taking into number three, Taking into account the submission of Mr. B.K. Sen, the learned counsel appearing on behalf of the judgment debtors, comma, the decree holder, the learned executive court shall also ensure through the revenue staff, through the revenue staff, as to whether by appointing a due commission as to whether the land which have been decreed by the coordinate bench of this court in RSA number 8/2001 is in possession of the decree holders, and if the decree holder is not in possession of the said land, the decree holder be put to possession by issuance of appropriate writ for delivery of possession. Anything more? I said that to verify through a commission as to who is in possession. And if they are not in possession, then to hand over the possession. Taking into, he knows it better. That is why these orders are being passed. Taking into account the recent judgment of the Supreme Court in the case of so and so, you know the citation? Then don't ask this type of. Regarding. I said there also. There also I said that to verify, to find out that, to identify. There I have asked him to identify. Here I have asked to verify. Because here the land is very identified. Because as per you, they are in possession. So it is identified. But in that case, it is identified. To identify, here to verify.
Item 4.
What are you challenging? What? Which order you are challenging? It's the council go and file an appeal before that court, senior division. Appeal. The learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised, submits that taking into account that the order which have been passed by the learned trial court is appealable, comma, the petitioner herein would be well advised to file an appeal before the court of the civil judge senior division at Kamrup Metro at Guwahati. Full. Who says? Go to Haryana. You see, there is a full bench judgment of 1983. That he would be, petitioner would be advised to file an appeal before the court of the civil judge senior division at Kamrup at Metro at Guwahati. This court have also duly taken note of the said submission, and in the opinion of this court, that the said order being appealable under Order 43, Rule 1R, comma, this court would not like to entertain the instant petition. Considering the above, the instant petition stands closed on withdrawal. Of liberty, however, would be, the withdrawal of the instant petition shall not prejudice the petitioner in the if so any appeal is preferred against the impugned order before the appropriate appellate court. Huh? You want time? What is challenged here? Settled. And what do you mean? The instant proceedings maintainable. When? When are you filing? 1 week. Otherwise, I dismiss your case. You don't have a case here. It has been submitted by both the parties that the matter has been almost amicably settled, and would be filing a joint petition before this court seeking an amicable resolution of the dispute. Taking into account, list this matter on 11th of June 2025. In the meantime, such applications be filed by the parties.
Item 6.
Appeal was dismissed. There's still an opportunity being given to both sides to go and apply for mutual consent. Why you're not doing it? From 2008, 7 years have gone by. Yeah. Why you're not filing a mutual? But for that, you have to go there. Mm. No, no. The problem is, Mr. Dotto, why I'm saying you are saying that we will mutually settle. Mutually settle for what? If you want to mutually settle for a divorce, then you have to go there. It cannot happen there. Yeah. But if it is a case for, because here the question will be for a mutual, there's a mutual settlement, is a specific provision. So therefore, it will have a mutual divorce. Whereas the other mutual settlement can only happen that you are going to come to him. That is the only way out. So are you agreeable for that? No. So then the only way out is for this court to admit the appeal. Isn't it? But once I admit the appeal, then the problem, would there be a problem for going for mutual divorce? So the only scope here is she has to come back to you. That is the only scope this court has. Either to give a divorce on merits, or the mutual, anything mutual happens is that she has to come back to you. But if you want a mutual divorce, then there is a specific provision before that. So therefore, I cannot touch that. So if you, because there you have been already given an opportunity by the trial court, thereby to go there and file a mutual divorce if you want to. If you can go for a mutual divorce, go there. You file it. Once you file, both of you file it, then I will do it. But how can I remove the 6 months now whether if you don't file? Isn't it? So I will keep this matter, won't admit it for the time. The reason why I may not once it is admitted, then again the problem will arise there. So you file there, both of you, if you are agreeable. Let us have this matter again in the month of July. July. From 2022, it is waiting. Nothing is happening for the last 3 years. You don't want it after 2 months. Then that is why I'm fixing it in the month of July. Then you have an adequate opportunity if you want to settle it and go there. But it cannot be here. The settlement is that she has to come back to you. That scope is not here like any other suit, because then it will go for a mutual divorce. I hope I'm able to make you understand that. How is it possible? Division bench may do, they may have a different idea, but the fact that when there is a provision out there in 13B which states about a mutual divorce has to go through another line which cannot be here. So here, appellate court also did, that is an initial proceedings. Mutual divorce is cannot be a proceedings under cruelty or the desertion cannot be converted into a mutual divorce by this court. That power this court may not have. But the Supreme Court can do so under 142. And there are judgments to that effect also by the Supreme Court. So taking into account that I fix it on so and so, in the meantime, party may explore to go there for filing mutual divorce if they so advised. First you file it, then you will take it up. It has been submitted by both the parties that they would like to explore the liberty so granted by the learned trial court for filing an application seeking mutual divorce. First, taking into account the above, list this matter again on 16th of July 2025. In the meantime, the party may explore the possibility for filing an application for mutual divorce.
7,
What are you challenging, Mr. Who? They. From Munsif number one or civil judge? Why? Why? From any senior court. Are they not exercising the same jurisdiction? Then, what is wrong with the judges? What about the other side? Service complete. Return with ineligible signature of a mandate for orders. Service complete. It's not necessary when it's not finished. I hope heard Mr. Siladitya, the learned counsel appearing on behalf of the petitioner. Petitioners, na? Huh? Petitioners. Kustumnan appears on behalf of the respondent on call. There is an application under Article 227 of the Constitution challenging the order dated 2/8/2023 passed by Mr. Counsel. Where's your prayer? Huh? What to do? Page? Prayer? Oh, I'll help you. What to do? What is your prayer? How? One more page you'll add. Tell me, give me a good idea. How is it possible? Huh? Where is your petition? This petition. Can help you with all these things. Engage counsel has filed this petition. Sorry, state of affairs. How do I allow this? You have to be careful. Heard Mr. Siladitya, the learned counsel appearing on behalf of the petitioner. Full stop. None appears on behalf of the respondent on call. Full stop. The petitioner have assailed the order dated 2/8/2023 passed in Mise case number 136/2023 arising out of title execution case number 29/2019, whereby the learned court of the civil judge, junior division number 4, Kamrup Metro at Guwahati, had rejected the application filed under section 151 for calling of the case report from the court of the civil judge, learned court of the civil judge, junior division number 1, Kamrup Metro, on the ground that the Court of the Learned Civil Judge Junior Division Number 1 Kamrup Metro is a senior court to the Court of the Civil Judge Junior Division Number 4 Kamrup Metro at Guwahati. Full stop. This court This court have duly perused the provisions of the Bengal Assam Agra Civil Courts Act 1887, and from a perusal thereof, the jurisdiction to be exercised by the Court of the Civil Judge Junior Division Number 1 is the same jurisdiction to be exercised by the Court of the Civil Judge Junior Division Number 4. Therefore, the rejection of the application by the Learned Court of the Civil Judge Junior Division Number 4 Kamrup Metro at Guwahati on the ground that the Court of the Civil Judge Junior Division Number 1 Kamrup Metro at Guwahati is a senior court amounts to failure to exercise the jurisdiction conferred upon the said court by law. Accordingly, this court therefore interferes with the order dated 2/8/2023 passed by the Learned Court of the Civil Judge Junior Division Number 4 Kamrup Metro at Guwahati and further disposes of the instant proceedings, directing the Learned Court of the Civil Judge Junior Division Number 4 to pass appropriate orders on the petition number 529/2023, thereby calling for the records from the Court of the Learned Civil Judge Junior Division Number 1 Kamrup Metro. With the above, the instant petition stands allowed, subject to a cost of rupees 10,000 imposed upon the counsel appearing on behalf of the petitioner for filing the instant petition in a very negligent manner.
Item 8.
Next time, এই রঙা কিটা বললো কষ্ট না Yes, Mr. Bhagavati. What? Same item, what is wrong with these courts? Huh? What has happened? Why? Huh? This is not same. Those cases where there was a direction passed for execution, the court makes a mistake of issuance of a writ of possession in respect of other land. And there they filed an application under 47 and also with a prayer, dismiss the year. So what does the court do? They not only recall the writ of possession but also dismisses it. So this is different. Here you are filing an application for modification of the boundary for the purpose of execution. So how are you saying that? Why? So you have only asked for schedule one. Then why? Where is it? Schedule one is what? Huh? Where's the decree? Page? Page 58. Tootland. So why there's no basis given in your petition? You have to give a good reason. What 40 feet into 15 feet. Who says? How can it be? This is with a patta. Then then tell me 518 belongs to whom? The schedule one land 519 belongs to whom? And that is a part of schedule two is a part of schedule one. No, no, no. What you want an amendment is in 519 itself. So 519, the entire land has been decreed in your favor. Huh? Does 519 only include your land? No, no, no. I'm asking you, does 519 is only one bigger, one katha 12 nature? There's no more land. You should have mentioned that in your petition. You have not mentioned anything. No, Mr. Counsel, you see, why should I give idea to Mr. B.K. Bhagavati? The petition does not contain any. Rightly rejected. The petition has been rightly rejected. You should have said the reason. Petition should have been specific. The entire 519 DAG has been declared in my favor by the plaintiff. Now, inside the DAG, Schedule 2 land is there. So, therefore, wherever it is, that should have been identified. Yes. So, your case should be that. What is this type of petition? Therefore, it has been held to be wrong. No, but the execution proceedings have been dismissed, na? So how do I restore? Pratibha Singh says what? That it is the duty of the court, either under 152 or 47, paragraph 17. But if tag number 519 includes other land, then it's a different aspect, ball game. Even the tag number, there's no quarrel with that. You have not given. Your tag number is given. You categorically say in the same tag and the same patta. What is their difference is that the boundary is different, and more particularly on the east, west, and south. North remains the same. What is your suit for? And what is their claim? Suit. Have they challenged the boundary in the trial court? Number? An Amin commissioner was not appointed. So which is the judgment? Which is the judgment I should follow now? Procedural thing says that, but what is the other one? You're not ready. How can I help you? Heard Mr. B.K. Bhagavati, the learned counsel, appearing on behalf of the petitioner. Mr. M. Hawk, who appears on behalf of the respondent. The supervisory jurisdiction of this court has been invoked, challenging the order dated 12/1/2024, passed by the Court of the Learned Civil Judge, Junior Division Number 1, Dorong at Mongoldoy, hereinafter referred to as the Learned Trial Court, Executing Court, whereby the title execution case number 1/2021 was dismissed. On the ground that the decree dated 10/9/2018 is an unexecutable decree. Full stop. The legality and validity of the said order dated 12/1/2024 have been challenged on the ground that the learned executing court had failed to exercise its jurisdiction in accordance with law, inasmuch as the learned executing court, who has the jurisdiction under section 47 of the Code of Civil Procedure 1908, for short the code, could have, is empowered to decide all questions relating to execution, discharge, or satisfaction of the decree. First, taking into account the said case, which have taking into account the said submissions so made by the learned counsel appearing on behalf of the petitioner, this court finds it relevant to take note of the brief facts which have led to the filing of the instant proceedings. It is seen that the petitioner is herein the petitioner is herein through the predecessor in interest had filed a suit before the Court of the Learned Munsif at Mongoldoy, which was registered and numbered as title suit number 29/2008 against the successor in interest of the respondents, against the predecessor in interest of the respondents. The said suit was filed seeking declaration of the plaintiff's right, title, and interest over the Schedule 1 land, as well as for ejectment of the defendant from the Schedule 2 land. It is relevant to take note of that during the pendency of the suit, both the original plaintiff and the original defendant expired. It was the specific case of the plaintiff in the said suit that the plaintiff was the patadar and possessor of the Schedule 1 land. On 1/5/2005, the defendant the original defendant approached the plaintiff to let out his plot of land, which was specifically described in Schedule 2 to the plaint, at measuring 35 feet into 12 feet, situated at the northwest corner of the Schedule 1 land, to the defendant on rent. The plaintiff rented out the Schedule 2 land to the defendant on a monthly rent of rupees 300 with effect from 8/5/2005 under an agreement dated 8/5/2005. On 8/5/2008, the plaintiff requested the defendant to hand over the vacant possession of the Schedule 2 land. However, the defendant did not hand over, and it is under such circumstances the plaintiff filed a suit seeking declaration of the plaintiff's right, title, and interest over the Schedule 1 land, which includes the Schedule 2 land, as well as for recovery of vacant possession of the Schedule 2 land within 1 week from the decree. It is seen that the Schedule 1 land have been described in the plaint. Schedule 1 land and the Schedule 2 land have been described in the plaint. It is apposite herein to mention that it is the categorical case of the plaintiff that the Schedule 2 land is a part of the Schedule 1 land. The defendant, the original defendant, filed the written statement. In the said written statement, apart from taking up various preliminary objections, it was categorically stated that the defendant has been in possession of the Schedule 2 land, Schedule 2 land, since 1997 by executing one after another lease agreement and paid the rent regularly to the plaintiff for the disputed land, and no areas of rent have been left out. It is further relevant to take note of that during the pendency of the suit, the original defendant expired and the petitioner respondents herein stepped into his shoes as legal representatives in the said suit. In the said written statement so filed, the legal representatives of the original defendant denied all averments made in the plaint and put the plaintiff to the strictest proof. However, at paragraph number 9 of the said written statement, it was stated that the defendant numbers 1, 2, and 3 had jointly started a grocery shop at the corner place of the Koirabari Majikuchi, Mongoldo PWD Road, and Majikuchi to Borhola Road, constructing a permanent house with CI seat and wooden post roof wooden sheet, uh, a permanent house with CIC roof and wooden post, filling up the roadside lowland, which was uncultivated, and spending rupees 10,000. The house constructed was adjacent to both the roads, and the land upon which the house was constructed was bounded with north inverted comma the boundary হিসাবে বলবো, north Koirabari, Majikusi dash Mongoldoy PWD Road, south Plaintiff, east roadside Sorkari land, west Majikusi Borkola PWD Road. It was specifically mentioned that the alleged grocery shop belonging to the said defendants did not fall within the land of the plaintiff. And the defendants have not occupied illegally the land belonging to the plaintiff, which have been described in Schedule 2 to the plaint. It is seen that the learned trial court framed 4 issues of which issue number 3 pertained to as to whether the defendant was possessing the suit land with effect from 8/5/2005 in pursuant to an agreement dated 8/5/2005 for 3 years. In addition to that, 2 additional issues were five, no, 7 issues. 7 issues. In addition to that, 2 additional issues were framed, being issue number A and B. Issue number A, additional issue number A is of relevance, which is reproduced here in under page 41. The learned trial court, by judgment and decree, dated 29/8/2018, decreed the suit in favor of the plaintiff and thereby holding that the plaintiffs have right title and interest. Plaintiff has right title and interest with respect to the Schedule 1 and Schedule 2 lands and is entitled to recover khas possession thereof. And the defendants were directed to vacate the Schedule 2 land and hand over the possession thereof to the plaintiff. It is relevant to take note of the discussion of the learned trial court as regards issue number A. Now, issue number A and B is relevant বুলি কৈ পেলাই দুইটা কোট কৰি দিব হা A and B. Issue number A and B, discussion of the learned trial court in respect to the issue number A and B. And while deciding the said issues, the learned trial court held that the issue number A was decided in the affirmative in favor of the co-defendants. And issue number B was divided in favor of the plaintiff. The resultant effect of the said decision in respect to the issue number A and B is that the learned trial court held that the newly added defendants, Kaur, and Gore, jointly started a grocery shop at the corner of the place of Koirabari Mongoldoy PWD Road by constructing a permanent house with CI seat and wooden posts in an uncultivated area. And it was also decided that a grocery shop belonging to the newly added defendants fell within the land of the plaintiff, and as such, the plaintiffs were the said defendants were liable to be ejected from the Schedule 2 land. Appeal, no appeal. There again, next, being aggrieved, an appeal was preferred by the respondents herein, which was registered and numbered as title appeal number 12/2018. And the learned court of the civil judge, Dorong Mongoldoy, who was the first appellate court, dismissed the said appeal. By the judgment and decree dated 15/12/2020. It is also relevant to take note of the discussion of the learned first appellate court in respect to issue number A and B. And confirmed that the construction of the grocery shop by the plaintiff, by the defendants, Kaur to Gore, was in the land of the plaintiff. No second appeal. Thereupon, an execution proceedings was filed by the plaintiff, by the petitioner herein, before the court of the learned Munsif number 1, Dorong Mongoldoy, that is the learned executing court, which was registered and numbered as title execution case number 1/2021. Footstep. The writ for delivery of possession was issued in respect to the Schedule 2 land. However, at the time of execution, the circle officer, Pathori Revenue Circle, by the communication dated 29/6/2022, as well as the lot mandal concerned, submitted a report that the boundaries so mentioned in Schedule 2 to the plaint, for which there was a direction for execution, decree for execution, there were certain difference. It is under such circumstances, an application was filed under section 151, read with 153 for the Code of Civil Procedure 19 of the code, seeking amendment of the judgment, amendment of the boundaries of the Schedule 2 land. First, the said application which was duly objected to by filing written objection by the respondents herein, was dismissed by the impugned order dated 12/1/2024, and consequently the execution proceedings were also dismissed, and it is under such circumstances the present proceedings have been initiated. Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the petitioner, submitted that the learned executing court in the impugned order appeared to be more concerned with the power under section 151 and 153 rather than taking into consideration that the learned executing court had the power under section 47 of the code to answer all questions in relation to execution, discharge, or satisfaction of the decree. Referring to the judgment of the Supreme Court in the case of Pratibha Singh versus Santi Devi Prasad and others, reported in 2003 2 SCC page 646, the learned counsel appearing on behalf of the petitioner submitted that the fruits of the decree that the learned executing court ought to have taken into consideration that the fruits of the decree could not have been denied on such technicality. First, inasmuch as it was the bounden duty, it was not only the duty of the plaintiff to properly mention the boundaries of the Schedule 2 land, but it was also incumbent upon the learned trial court in terms with section Order 7, Rule 3 and Order 20, Rule 6 to ascertain the exact boundary of the Schedule 2 land. He further submitted that this defect could have been cured in terms with section 1452 of the code by the learned executing court, as well as at the stage of by exercising the powers under section 47 as have been held by the Supreme Court. Footstep. The learned counsel further submitted that the decision in respect to issue number A and B has great relevance, wherein the learned executing court, the learned trial court, as well as the learned first appellate court, in spite of the boundary duly mentioned in the written statement filed by the legal representatives of the original defendant, had held that the said land fell within the Schedule 1 land. And as such, it was the duty of the learned executing court to identify the exact area and thereupon execute the decree. Anything more? Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, respondent submitted that a perusal of the application filed under section 151 and 153 does not mention anything what the learned counsel appearing on behalf of the petitioner has submitted today. It is a totally new case which is being sought to be brought before this court, that too in exercise of the powers of the revision and jurisdiction of this court. He therefore submitted that reasoning so assigned by the learned trial court in the order dated in the impugned order dated 12/1/2024 for rejection of the application under section 151 and 153 cannot be faulted. Full stop. He further submitted that as it is now an admitted fact that the decree in the question, the decree for recovery of possession in respect to the Schedule 2 land cannot be identified, the learned executing court was justified in rejecting the dismissing the execution proceedings, isn't it? Anything more? Learned counsel for the respondents further submitted that what the petitioner now seeks to execute is in respect to a different plot of land, which the petitioner could have very well taken appropriate steps at the time when the suit was pending or even when the appeal was pending. No such steps was taken, and as such, the question of exercising the supervisory jurisdiction of this court does not arise. Okay? Sure. Let me come back. Find the judgment, 2003, 8 SCC page, get the page. Randhir Singh's judgment. Oh, Hanani. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration. From the judgment and decree so passed by the learned trial court, which has been affirmed by the learned first appellate court, it appears that the learned trial court had declared the right, title, and interest in respect to Schedule 1 and Schedule 2 in favor of the plaintiff, and further decreed that the plaintiff is entitled to recover khas possession thereof. The defendants were further ordered to vacate the Schedule 2 land and hand over the possession thereof to the plaintiff. This court further, in the foregoing paragraphs of the instant judgment, have also duly taken note of the discussion made by both the learned trial court as well as the learned first appellate court in respect to the additional issue A and B, wherein both the courts have come to a concurrent finding of fact that the defendants oblique the respondents herein had constructed the grocery shop had started a grocery shop at the corner of Khairabari Mongoldoi PWD Road by constructing a permanent house with CI seat and wooden post in an uncultivated area and the grocery shop belonging to the newly added defendants fall within the land of the plaintiff. First, it is further seen that during the period, during the course of execution of the decree, it came into light that the boundaries so mentioned in Schedule 2 do not match with the possession of the defendants, oblique the petition respondents herein. And it is under such circumstances the petitioners had filed the application under section 151 and 153 of the code seeking amendment to the boundaries of Schedule 2. Schedule 2, so that the decree could be executed. It is further relevant to take note of that Schedule 2, as per the plaintiff, is a part of Schedule 1 land. And the said application filed under section 151 and 153 also states the same. What is sought to be corrected is the boundary inside the Schedule A land, Schedule 1 land, which has also been decreed in favor of the plaintiff. In this regard, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Pratibha Singh, Supra, wherein the Supreme Court observed that it is not only the duty of the plaintiff, but it is also an obligation cast upon the trial court to act in terms with Order 7, Rule 3, to ascertain the exact boundaries of the land in question. In terms with Order 7, Rule 3 and Order 20, Rule 6 of the Code. It is also mentioned in the said judgment that in order that the decree which is being obtained by the plaintiff, by a party, is not reduced to a paper decree, the executing court would have the powers under section 152 or under 47 to pass appropriate orders, thereby correcting the boundaries. Paragraph number. Give it to me. Paragraph number 16. Paragraph number, yeah. Paragraph number 17 of the said judgment being relevant is reproduced herein under. However, it is taken note of. However, it is seen that the learned executing court, instead of taking appropriate steps in terms with section 47 of the code, dismissed the entire execution proceedings on the ground that the decree was not executed. And that too without considering that the Schedule 2 land, considering that in respect to the Schedule 1 land, there was a decree for right title and interest, and for recovery of possession, and Schedule 2 land was a part thereof. First, no, it has been found that is Schedule B, and that is Annexure B, what you call Additional Issue B. Mr. Counsel, that is Mr. Counsel, that is the order which I am proposing to pass on. सबसे की लिख लें? First, it is also seen that the learned trial executing court in the impugned order, had observed that any correction in the boundaries of the Schedule 2 land would amount to going behind the decree, which in the opinion of this court would not be so, taking into account the decision so passed, taking into account that the judgment and order so passed by both the learned trial court as well as the learned first appellate court in respect to issue numbers, additional issue number A and B. More so when it is a settled principle of law that a decree is the fallout of the reasons so assigned in the judgment and decree, judgment. So taking into account the above, this court therefore interferes with the order dated 12/1/2024 by which the title execution case number 1/2021 was dismissed. First, accordingly, the instant proceedings, therefore, stands disposed of with the following observations and directions. The dismissal of the title execution case number 1/2021 by the impugned order dated 12/1/2024 is interfered with. Number 2. The title execution case number 1/2021 is restored to the file of the learned court of the Civil Judge Junior Division number 1 Dorong at Moldo. Number 3. The learned executing court who has the powers under section 47 shall exercise the powers under section 47 to identify as to whether the Schedule 2 land falls within the ambit of Schedule 1 land. And upon identification thereof, it is found that the Schedule 2 lands falls within the ambit of Schedule 1 land, proceed with the execution of the decree as per the mandate of law. Number 3 and number 4, Fuster. Taking into account that it is also the duty cast upon by this code under section 47 to the learned executing court, comma, the learned executing court shall take appropriate steps for the purpose of execution, comma, discharge or satisfaction of the decree. First, next. This court, further taking into account that both the parties are duly represented before this court, directs both the parties to appear before the learned court of the so-and-so on 10th of June 2025 for further proceedings of the execution proceedings.
Upgraded item 31.
That's it. Wait, what is this IS for? IA for what? Huh? IA for injunction. Huh? IA for this court passed an order. So what are you challenging? Who is challenging what? Huh? Ah. Hmm. Hmm. You're the respondent. Yeah. Ah, this way. You come here. Very difficult. So you see, Mr. Rajwal Bhuiya, I am not going to go for vacating or all this business I don't have. It will be fully disposed of, isn't it? Whether the injunction should be there or not. That's the question. Who is the plaintiff? They. You file the written statement, come counterclaim. What is your counterclaim for? Hmm, hmm, hmm. And they now want to construct. And the trial court passed the injunction. Injunction for what? Now only one thing which okay. Now you have no problem in the that they are in possession. They are in possession. Are they in possession of the suit land? No, my only question is, are they in possession? So if they are in possession, the injunction order so passed not to disturb their possession seems to be okay. We'll come to that. We'll come to that. Now, did you file an injunction application there not to construct? My question is that. Very well, all these things are okay. Now, my question is, did you file an injunction application before the trial court that he raised should not construct? Where? Okay. So here the appellate court changed it, saying that okay, status quo will be maintained, including construction. So you support that order. You support that order. Yes, when is your senior coming? We'll dispose it of. Don't worry. Just wait for some time.
Item 9.
What are you challenging, Mr. Hussain? Stay. Where's the other side? Hmm? So why didn't you take that ground there? What does the court say? Where's the plaint? Where is the plaint of the earlier suit? First suit. Page 13. 1-3 is the second suit. You filed the second suit. For recovery of possession of the plaintiff over the suit land described in Schedule B by ejecting the defendant, declaration of possessory title, declaration of sale deed was never executed by so and so. Declaration that is set up for precept. What is the other suit? Both are same land. Yes. There. So here in the first suit, they are claiming that they have 2 bighas, right title in respect 2 bighas of land covered by Dag number 273 of so and so, bounded by so and so plaintiff. And here your claim is on respect to Schedule B land of so and so, and in the boundary of so and so road, Prabhat. Huh? So why didn't you file a counterclaim? Here they are asking for partition, first suit. That is a different thing. I am not on that. But the thing is, they are asking for partition. What about the service upon the respondent? Both the suits are pending where? You do one thing, you file an application on the 151 here. Okay? And the second thing is you effect service upon respond number 1 and 2 by way of the stick. This 1 and 2. Others not necessary because 1 and 2 were the plaintiffs in the other suit. Na? So you do one thing, you 1 and 2, you serve them. By way. Heard Mr. B. Hussain, the learned counsel, appearing on behalf of the petitioner. It is seen that the service upon the respondents, though are complete, but none has appeared upon the respond number 1 to 5 are complete, but none has appeared on behalf of the respondents. Full stop. The present proceedings pertains to stay of titles, pertains to an order passed by the court of the Civil Judge Junior Division number 2 Borpeta dated 12/4/2024, whereby title suit number 38 oblique 2023 have been stayed pending disposal of title suit number 222 oblique 2022. This could further have taken note of that title suit number 222 oblique 2022 is filed by the respondent number 1 and 2 in the instant proceedings. Although the said respondents have not appeared, however, as a matter of abundant caution, this court would insist upon the petitioner herein to file an application, file the effect service upon the said respond number 1 and 2 by way of the stay routed through the registry of this court and file an affidavit of service on or before the next date. The next date is fixed on 18th of June 2025. Mr. B. Hussain, the learned counsel, further submitted that though the subject matter of the suits of both the parties. Are in respect to the present same dag and patta number. But taking into account the case set out by the respondents in title suit number 222/22 and the case set out by the petitioner in title suit number 38/2023, the ends of justice would be met if both the proceedings are analogously tried. He therefore submitted that he would file an application under 151 on or before the next prior to on 18 by 16th of June 2025. Can you file it by 13th, Mr. Hussain? 13th. File that application by 13th. 1-3. By 13th of June 2025. So taking into account the above, list the matter again on 18th for further 18th. Full stop. Taking this court also is of the view. No, full stop. This court further takes note of that by an order dated 27/11/2024, it was observed that the interim order of the petitioner would be considered upon appearance on the other side. It is seen that the service is otherwise complete as regards the respond numbers 1 to 5. However, none has appeared. Considering the above and the and considering the above, it is the opinion of this court that if the title suit number 222/2022 is allowed to proceed further, that too when the petitioner wishes to file an application under section 151, it may result in difficulty in permitting analogous trial of both the suits. Accordingly, the further proceedings of title suit number 222/2022 pending before the court of the learned junior division number 2 Borpeta shall remain stayed till the next date.
Item 10.
Yes, what is this? What is the order passed in the Miss Appeal? Huh? No. What is the order passed by the appellate court? by them. Where is that page? I don't understand what is written down below. Page 39, 40, 38. What is this? What is written all this thing? Judgment is prepared in separate sheets. In view of that, it is held that plaintiffs a prima facie case with a fair chance of success in this case, and it is further held irreparable lawsuit because if the injunction is not granted. Therefore, it is allowed in favor the respondent hearing are restrained from alienating the suit plan to anybody in any manner, making permanent construction therein, create any encumbrance on their name. Okay, now Mr. Mohanto, what is this? This judge has written at page 128, the last paragraph. I don't understand. What is this? A copy of this order along with the photo. Ah. Then paragraph 31. So, not to sell and not to construct. So, what is the plaintiff's case? Hmm. Based on a it's a registered deed. Then so you file a counterclaim. Huh? Suggested means? Oh. I see. So there is a say lease deed, registered lease. It was acted. Who is in possession? Are you going to sell it? Are you going to construct it? Has the correction been done? So the order has been passed, status quo be maintained. Maintained. Yes, Mr. Mohanto. You are the plaintiff. You are asking that they should not dispossess you. Yes. A decree for khas possession of the land of Schedule A by evicting the defendants. Defendants are they. And then they dispossessed you. Now what do you want? So they are saying that they are not going to construct. Maintain status quo as regards possession, title, and possession, title, possession, and construction. No, everything will remain as it is. And I give the leave to both the parties, if necessary, during the pendency of the suit, to file appropriate application before the trial court, showing good reasons if necessary. The heard Miss S. Dasgupta, the learned counsel, appearing on behalf of the petitioner, and Mr. T.J. Mohanto, the learned counsel, who appears, senior counsel, assisted by Ms. P. Bhattacharjee, who appears on behalf of the respondent numbers 1, 2, 1 and 2, 1 and 2, 1 and 2. And Mr. K.R. Bhattacharjee, who appears for respondent number 19 and 20. Status 19 and 20. Gusto. The supervisory jurisdiction of this court have been invoked, challenging the judgment and order dated 27/2024 passed by the learned additional district judge, Dhubri district in Miss Appeal number 1/2024, whereby the learned first appellate court directed, restrained the petitioner's urine from alienating the suit land to anybody in any manner, comma, making permanent construction thereon, comma, create any encumbrance on the land, damage the land, and changing the status of the disputed land. You were evicted in the year 2018 and you filed a suit in 2000? Huh? 22. They are the owner of the land. Understood. You are not in possession. You want to recover the possession. You are not in a possession from 2018. So therefore, why you are saying that, asking them not to damage the land and changing the status of the land? I understand. They shall not construct or alienate. Understand. But what business do you have? They will not sell it. That is what I'll pass. But what is all these other things? Create any encumbrance on the land, damage the land, and changing the status of the disputed land. No. Page 122. Till the alienation, construction, all are understood. But what is this? Does the owner of the land do not have the power to mortgage the land? Your lease is for 99. Lease, does the lessee has the absolute right? Do you say that the owner would not have the right? That will be subject to the lease. Then how can you all these orders be passed? Again, I am saying they are not going to alienate. That is what I am continuing. Alienation and no permanent construction. That's all. Okay. The learned counsel appearing on behalf of the petitioner submitted that a challenge made to the impugned order is limited to the directions so passed restraining the petitioners from creating any encumbrance on the land, comma, damage the land, and changing the status of the disputed land. See, further submitted that the question of damaging the land and changing the status of the disputed land does not arise, taking into account that the said land have been used all along for gardening purpose. She further submitted that the petitioners who are the owners of the land are not going to alienate the suit land as well as raise any permanent construction thereupon till the disposal of the suit. She, however, submits that the petitioner, the plaintiffs also cannot, during the pendency of the suit, take any steps before the authorities which will affect the title of the petitioners who are the defendants. And as such, appropriate orders are being sought for by way of the present proceedings under Article 227 of the Constitution. I've also heard Mr. T.J. Mohanto, the learned counsel, appearing on behalf of the petitioner respondents who are the plaintiffs, respondent number 1 and 2 who are the plaintiffs, who submits that there is a registered lease agreement, deed for lease in favor of the plaintiffs for a period of 99 years, and the petition and the plaintiffs were dispossessed in the year 2018. As per the plaintiffs has reasonable apprehension that the petitioners herein who are the defendants would alienate the said suit property and also raise construction, and thereby it would be difficult. It would not only lead to multiplicity of proceedings, but also would require, but also any decree so passed in the court in the suit would not be sufficient, and also would create raise permanent construction which would prejudice the case of the plaintiffs. This court have duly perused the impugned order dated 27/2024, passed in Miss Appeal number 1/2024, and have also heard the learned counsels appearing on behalf of the parties. From the facts so narrated in the plaint as well as the submissions of the parties, it is apparent that the petitioners who are the defendant numbers 1 and 2, you are 1 and 2, are the owners of the suit land. And as on date, there exists a registered deed of lease dated lease in favor of the plaintiffs numbers 1 and 2. They are the plaintiff number 1 and 2. Then it has been alleged in the plaint that in the year 2018, the defendants number 1 and 2 dispossessed the plaintiffs. Per contra, the defendants in the numbers 1 and 2 contend that although there was a registered lease deed, but it was never acted upon, and the plaintiffs have been all along in possession of the suit land. Taking into account the observations so made by the learned First Appellate Court, thereby applying the three golden principles for the grant of an injunction, it is therefore the opinion of this court that the said order so passed by the learned First Appellate Court dated 27/2024 needs a slight modification to the extent slight modification. Accordingly, the instant proceedings therefore stands disposed of, thereby directing both the parties slight modification in view of the allegations and counter allegations made by the petitioners as well as the respondent numbers 1 and 2. Accordingly, the instant proceeding stands disposed of, thereby directing both the parties, the plaintiffs as well as the defendant numbers 1 and 2. 1 and 2 is okay, na? To maintain status quo as regards title, possession, as well as construction during the pendency of the suit. It is, however, observed that if during the pendency, if the suit is pending for a long period, liberty would be there on the part of both the parties to seek modification of this order.
Eleven.
What is this essay of business? Remand. Where is the order of remand? Yes. So the question is, you are the decree holder. Whatever may be, you are the decree holder. Somebody filed an order 21 rule 97. In that proceeding, evidence was not permitted to be adduced. So now it is being remanded back, thereby permitting him to adduce evidence. So what is wrong? Father and? Okay. So here the suit was filed on their behalf as the, then how Order 21 Rule 97 is maintainable? On the ground that they allege fraud against the power of attorney, isn't it? That's a separate cause of action. So therefore, they should go for a suit for declared a separate suit. Chalo. We need to finish off very early this matter. This matter should not. And why should we? We don't require the records. This is a short point involved. This is an appeal filed under Order 43, Rule 1U of the Code of Civil Procedure 1908, challenging the order dated 21/2/2025, passed in Miss Appeal case number 1/2025, whereby the learned court of the Civil Judge Senior Division, Baksa at Musalpur, had remanded the said appeal, remanded, had passed an order of remand back to the learned executing court to decide afresh the proceedings under Order 21, Rule 97/100/N101 by providing opportunity to the appellants therein to produce evidence in support of their claim. The learned counsel appearing on behalf of the appellants herein submits that the learned executive, the first appellate court erred in law in not taking into consideration that the proceedings under Order 21, Rule 97, read with Rule 100 and 101 of the Code was not maintainable, taking into account that the suit was filed at the behest of these behest of the respondents numbers 1 and 2, who were respondent numbers 1 and 2, through their power of attorney. Full stop. The learned counsel appearing on behalf of the appellants further submitted that the mere allegation of a fraud being committed by the power of attorney would be a completely separate cause of action, which could not have been brought within the purview of Order 21, Rule 97 and 101 of the Code. First, taking into account the above, the instant appeal is admitted. First, as the question involved is a short question of law, the requirement of the records are not necessary. First, steps be taken against the respondent numbers 1, 2, and 3 by way of registered as well as usual. In addition to that, steps be taken by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. First, list the matter again on 25th of June 2025. Appeal is this. This is an application filed under Order 41, Rule 5, 41, Rule 5 of the Code of Civil Procedure, seeking stay of the order dated 21/2/2025, passed by the learned Civil Judge Senior Division Baksa at Musalpur in Miss Appeal number 1/2025. This court had duly, after recording the due reasons, have admitted the accompanying appeal. Full stop. The question of staying the order dated, full stop. This court further takes note of that the question of staying the order dated 21/2/2025 does not pass by the learned civil judge senior division Baksa Musalpur in Miss Appeal number 1/2025 does not arise, taking into account that any stay any stay of that order would be amounting to allowing the said appeal at this stage. However, this court, for the ends of justice, stays the further proceedings of petition number 447/24 pending before the learned court of the Civil Judge Junior Division Baksa Musalpur in title execution case number. What is the number? 5/5/2025 till the 20 till the next day. Isn't it? Can I stay there? The appeal will start. No. I disposed. Is your registered agreement? Then you are trying to stop a surfacing proceedings. Okay? Surfacing proceeding. Then somebody else has already filed a suit. Who sold what? Pipco sold it to by a registered sale deed. Who is Anita Sharma? No, who is Mrs. Anita Sharma? Anita Sharma is not before this court. Anita Sharma is not before. She's a respondent. Then the question is, should I? The question here is very simple. Notice has been issued. The court, after giving due reasons, have said that I am only issuing a notice now. Yes. Okay. Where is the threat of eviction? Now forget about that in your petition. Where? No. Where? Page 53. Page 53. Where is your agreement? Etna is a partnership firm. Then but this agreement is only for 11 months. Where? Then, how am I going to be satisfied? So what? First of all, if your other partners are willing to give it, then if it is a partnership at will, your partnership there is no partnership at all. The agreement is only with the partnership firm. The partnership firm is not before the court. Then what right you have? So what? You are in possession, you are a trespasser. Trespasser has no right against the young. No injunction. So your case is now what has happened. There were three partners in Chetna. Anita Sharma, Rajesh Goswami, and Devashish Kumar Sinha. David. It is mentioned at page 36. Then there were three partners. Two of the partners have left to you. And now you want to keep the possession out there. This is what your case is. It is there, represented by his partners Anita Sharma, Rajesh Goswami, and Devashish Kumar Sinha. So these are two partners. One of the partner has left you. So it is a fight between both of your partners. And this agreement is only for 11 months. Then, whom are you tendering rent now? Whom are you paying rent? Then, what right you have? Then you don't have a right. There's no procedure. Procedure, they will follow it. The moment I reject it, then there will be more air. My partner wants to hand over the keys. There the problem arises. Page 41 is the communication wherein it is apparently clear that on 10th of April, the keys will be handed over. Now you want an injunction. First of all, whom are you tendering the rent? Whom? You don't know. You know now who is the owner. Now you know, Mr. Chaudhary, who is the owner. So then you don't admit it. Are you still tendering the rent to the earlier owner? Then that also you are not doing. Then chalo. This is a case of dismissal right away. Today I have not dismissed anything. First case of dismissal. Now, heard Mr. S.P. Chaudhary. No, I don't issue notice. Why should I issue a notice of this? It will have more disastrous consequences upon you if I issue notice. One notice is already there. Why should I have another one? Heard Mr. S.P. Chaudhary, the learned counsel appearing on behalf of the appellant. This is an appeal filed under Order 43, Rule 1R, read with Section 104 of the Code of Civil Procedure, challenging the order dated 8/5/2025, passed in Midze case number 428/2025, arising out of title suit number 285/2025, whereby the learned court of the civil judge number 2, Kamrup Metro at Guwahati, did not pass, was of the opinion that without issuance of notice, comma, was of the opinion that the case was not a fit case for passing an ad interim ex parte injunction. First, the learned counsel appearing on behalf of the appellant submitted that although there were various averments being made that the appellant herein was under the threat of eviction, but the learned trial court did not pass an ad interim ex parte injunction, which was the need of the hour, taking into account the facts involved. Full stop. It is under such circumstances the present appeal has been filed, seeking certain protection till the next date so fixed by the learned trial court. That is on 6/6/2025. Full stop. This court have perused the materials on record and taking into account that the learned first trial court, which is the court of the first instance, after recording due reasons in its order dated 8/5/2025, have exercised its discretion not to grant an ex parte ad interim ex parte injunction and is of the opinion that and that too by assigning due reasons, this court would not like to exercise its appellate jurisdiction in against the order dated 8/5/2025. Full stop. Accordingly, this court finds no merit in the instant appeal, for which the appeal stands dismissed. Full stop. Before parting with the record, this court, however, observes that the petitioner, the appellant herein, would be at liberty to file an application under 151 before the learned trial court if there is any urgency, and the learned trial court shall duly consider the same.
Pending item 31.
No, first of all, did you take the permission? Did you take the permission from the trial court? Then look here, I am taking an injunction very well. But if I am also want to make construction out there, did you take that? Because on one hand, you are taking an injunction that they should not dispossess you, they should not disturb you, do anything. Very well, you can get it. But if you raise construction on the land where they have filed a counterclaim, what is the balance of convenience? Tell me. Understood very well. But if you are raising construction when there is a counterclaim, very well, now you are making a permanent construction. If you are making a permanent construction by obtaining a stay out here, then it is not that. Why you cannot do so? How can you raise construction? No, let us see in your plaint where you have mentioned that you are raising construction and they are disturbing your construction. No, 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 I'm asking you. Let us see how the trial court deals with this. Where does it say that you can go ahead with the construction? Trial court's order, madam, is not good. How can they allow you to construct? In fact, what you are trying to get a prohibitory injunction for construction at the in the form of a mandatory injunction. This is how you are doing it, isn't it? That you want to construct because you have students, you have opened the school in 2021, and now after the school is being opened, you have more students. So with Kacha, you cannot do. So you want a Pakka one. So you are making construction. They will give an undertaking. Let them give an undertaking. Which there's a reported judgment of mine where Mr. S. Ali had appeared. He reported in 2025. Find it out how the undertaking is to be given. That we will do. There are the undertaking has to be threefold. First, that any construction so made out there, if in the case their counterclaim is decreed in their favor, they would not require any further decree of the court. You will be demolished. You will have no problem in handing it over to them or demolishing as per their wish. Number one. Number two, you shall not create any third party rights on that or encumber that property. Whatever may be, you cannot encumber that property. Just for example, can't take a loan for that. And number three is another one. You just check that order. And third party rights you cannot create. So these are the things you have to give, file an undertaking, and then the balance of convenience will shift to you. and he would not have objection. Ms. R. Chaudhary, the learned counsel appearing on behalf of the appellant, petitioner, submits that she would like to get, the petitioners would like to submit an undertaking before this court that in the circumstance the counterclaim is decreed in favor of the respondents herein, oblique the defendants. The defendants oblique the respondents herein, the petitioners here would have no objection in, so would not insist on a separate decree for recovery of khas possession over the building in question, or would have no problem. It will submits that she would give an undertaking that in the circumstance the counterclaim is decreed in favor of the defendants oblique the respondents herein, the petitioners oblique the plaintiffs shall hand over the possession over the constructed building to the counterclaimants oblique the to the respondent oblique the defendants in the suit without there being any decree sought, without there being any relief sought in that in the counterclaim, that the petitioner shall not encumber the said building in any manner whatsoever during the pendency of the suit, and further, no third party rights would be created on the said land or upon the said constructed building. Taking into account the above, list this matter on 9th of June 2025. It is observed that till such undertaking is not served, it would not be proper on the part of the respondent of petitioners to proceed with any construction over the permanent structure.
Admission item 13.
You see that judgment, madam? No permit. What is the direction? No recovery. Hello, pay. And recovery, I'll bring it. That is the only thing. Okay. The heard Mr. T. Kulta, the learned counsel appearing on behalf of the appellant, the instant appeal is filed under Section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 15/2/2025, passed in MEC case number 33/2021, whereby the learned tribunal, Learned Motor Accidents Claims Tribunal, Gwalpara, had awarded an amount of rupees 15,10,830 along with interest at the rate of 7% upon the petitioner, upon the appellant, from the date of filing of the claim proceeding, and along with interest at the rate of 7% from the date of filing of the claim proceedings, claim petition. And the appellant insurance company was directed to pay the award to the claimant within 1 month from the date of the said order. First, the learned counsel appearing on behalf of the appellant have submitted that the learned first tribunal had failed to take into account that there was a violation of the policy conditions, and as such, the directions settling of the entire liability upon the settling of the liability upon the appellant insurance company was not in accordance with law. First, taking into account the said ground of objection, the instant appeal is admitted. Call for the record steps be taken upon the respondent numbers on the respondents library. Respondent numbers 1, 2, 3, 4. First, list the matter upon receipt of the records. First, this is an application filed under Order 41, Rule 5 of the Code of Civil Procedure 1908 for stay of the judgment and decree, judgment and award dated 15 to 2025, passed in MEC case number 33 of 2021, arising out of 33 of 2021 by the Learned Motor Accidents Claims Tribunal, Gwalpara, whereby an amount of rupees 15 lakhs and so 15 lakhs 10,830 along with interest at the rate of 7% per annum have been 7% per annum bracket of the except upon the amount calculated on the head of future prospects bracket close from the date of claim filing of the claim petition paid by the be deposited by the be paid by the appellant insurance company. First step, the accompanying appeal has already been admitted. First step, taking into account the above, the instant this court have been admitted on the ground that there was a violation of the policy constitution. In that view of the matter, this court directs the appellant insurance company to deposit the amount of rupees 15 lakhs 10,830 along with interest at the rate of 7% bracket except upon the amount calculated on the head of future prospects bracket close from the date of filing of the claim petition before the tribunal registry before the registry of this court. First step. Within 6 weeks from today. The claimants who are the respondent numbers 1, 2, and 3 would be at liberty to file appropriate application before the registry of this court. And the no, you go to the tribunal. Deposit before the tribunal, before the tribunal. Full stop. The learned tribunal thereupon shall apply the said amount in terms with paragraph number 33 and 34 of the impugned judgment and award. Full stop. Any amount to be disbursed to the claimant shall be done by the learned tribunal only through bank transfer. Full stop. Full stop. Next. This court further observes and directs that in the circumstance the appeal is allowed, this court shall pass appropriate directions for recovery of the amount so directed to be deposited by this court to the upon the appellant company, insurance company, to be realized from the owner of the vehicle, that is the respond number 4. 3, na? 3 or 4? 4. Respond number 3. 3. With the above, the instant petition stands disposed.
Item 14, hearing under Order 41, Rule 11 CPC.
Huh? Then what is your grounds? Yes, Mr. Das. Where is the discussion as regards title of the plaintiff? Whom? Your proof. Your proof. Title. Where is the discussion? Where is the discussion by the first appellate court? Huh? No, there was, how many pattas are there? Patta number 175 is in whose name? One is Patta 101, which had 7 bighas, 2 katha, 3 lechas,
10.
of which 7 bighas have been sold to the father of the defendants.
Yes, the entire schedule A land belong to us.
5 bighas.
7 bighas, madam. Two
No,
pattas are
but 7 bighas have been sold to the
7 bighas
defendants.
sold to them.
Then
The remaining 5 bighas, for which,
5 bighas is in Patta number 175.
yes, 175.
There is schedule B and C land.
Yes. Also, may kindly see para number 22 and 23 of the impugned judgment.
So merely on Jamabandi, Patta not disclosed.
Perhaps, madam, not executed.
Certified copy of the Jamabandi of Patta number 175 and certified copy. That's all. This agreement for sale is what? Of 1980.
1980.
Then how can a decree be granted? Certified copy of a Jamabandi Patta number. Patta number is different, no? Certified copy of the Jamabandi is being given.
Yes.
Hmm.
But if your lordship will look at their pleas, my lord, they have no case.
Forget about their plea.
We are
Are we
pattadar.
going to go by the weakness of the defendant's case?
But my lord, admittedly, we are pattadars. They have admitted our title because they say that they have purchased the land from us. So they have admitted our title.
So what is this exhibit A and B?
That is some agreement for sale, my lord, which they allege to have been executed by the plaintiffs in their favor. But they have not, my lord, in all these years, my lord.
Now,
they-
are these exhibits for these schedule B and C land? So when the Patta land happened, what happened? Mister? And so the learned counsel appearing on behalf of the appellant and Mr.
Yes, that's not.
appears on behalf of the respondent number
sole respondent.
1 and 2.
One.
Is an appeal filed under section 100 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 6/2/2025, passed in title appeal number 7/2024 by the Court of the Learned Civil Judge, Senior Division, Baksa at Musalpur. The instant appeal is admitted by formulating the following substantial question of law: whether the learned first appellate court was justified in decreeing the suit in favor of the plaintiffs in respect to the Schedule B and C land merely on the basis of certified copies of the Jamabandis, which are the record of rights. Call for the records, steps, as the respondent, call for the records, as the respondents are duly represented by Mr. Estes, extra copy of the memo of appeal be served upon him in 2 days. I condemn. Is an appeal filed under, is an application filed under Order 41, Rule 5 of the Code of Civil Procedure 1908, seeking stay of the judgment and decree passed by this court. Judgment and decree passed by the Court of the Civil Judge, Senior Division, Baksa at Musalpur, entitled Appeal number 07 of 2024. It is seen from the judgment and decree passed by the Learned First Appellate Court, the said First Appellate Court, that there is a decree for recovery of possession over the Schedule B and C land by evicting the appellants herein. Considering the above and taking into account that the accompanying appeal has been admitted, the instant application stands allowed, thereby staying the judgment and decree dated so and so, passed in so and so.
But they had a weak case.
Ah?
Their case was not that not perfect, because on one hand they said that they had sale permission agreement. On the other hand, they said on the very day they came into hostile position. Contradictory please.
We only require the records.
Item 15 and connected item 43.
Yes, what is this?
It's a regular second appeal matter. The case is not that strong one.
Huh?
But the case is like this. There are two pattadars, Chandra Mohan Rai and Mohendra Mohan Roy. They had around 8 bighas of land. So Mohendra Mohan Roy sold 1 bighas 15 lessa to the father of the plaintiffs, Kabir Mullah. Out of that, Kabir Mullah during his lifetime sold 3 katha 10 lessas of land to the defendant number 2. Thereafter, Kabir Mullah had around 3 katha 5 lessas of land. So after his death, as per Islamic law, the plaintiff number 1, who is the son, he got 1 katha 8.84.
Where are the substantial questions of law?
Substantial question of law, at page number 14.
Page number?
14.
Whether the learned courts below were correct to declare the right of the plaintiff over the plot of land measuring so and so, when admitting plaintiff number 1 were only entitled to 11.55. The land below legally declared right of land interest in recovering the existing. So what is your case?
Our case is that we also had land in the Sud Patta. But without even declaring our share, the court below directly said that the plaintiffs are entitled to their suit land without even determining the shares of the other pattadas, because it was an Azmali Patta. And the next thing is that, the plaintiff number 1 and 2, the plaintiff 1 is the son, plaintiff 2 is the wife of the predecessor. So plaintiff 1 had already sold his land and only around 11 lessas of land remain with the plaintiff number 1 and 2. The rest of the land, my lord, are with the sisters who have been made pro forma defendants number 1 and 2. But my lord, the thing is that technically, my lord, plaintiffs are entitled to only 11 lesses of land, my lord. How can the court below direct that, my lord, they are entitled to only 2 kathas of land, my lord, which they are not technically, my lord, entitled?
Concurrent.
Concurrent.
And neither they have produced any evidence as regards, so only filing written statement. Thereafter, my lord, they have not produced any evidence, neither they have sold it, nothing.
I'm only asking, what is your land?
My land is, my lord, 1 biga, 15 latches, out of which I sold, my lord, 1 kata, 5 latches, and another 2 katas. Thereafter, 2 katas remains with me, which the court at para 12, the first appellate court, while discussing has held that. Para 12.
Why is he saying about 11.55 liters?
My lord, that is his submission before he had this court. But the court held that because they tried to file an application under Order 41 Rule 27. There, that was also not, that was rejected virtually. Court held that the appellate court, on the basis of 2012 ATSCC, that 148 judgment, my lord, the court held that the appellate court is in a position to pass the judgment. So I will not allow this Order 41 Rule 27. And because they have an ample opportunity, when they has the opportunity of giving evidence, lot of opportunity are giving, they have not produced anything. So, my lord, the court, on the basis of our admitted
So
fact
the
that
suit proceeded ex parte.
expert, well, only they have filed it in statement, nothing more.
Thereafter, they did not cross.
My lord, they have chief and cross to me, my lord, but they have done the cross as regards me, my lord, the plaintiff. But they have not given any
Okay,
evidence.
everything is on record, my lord. They already were admitted in their plain, my lord, regarding the purchase which was made by my father, my lord, from the original Pattata. That is on the record, my lord. We are not going beyond the record.
Where is the plaintiff?
Para number 8, my lord, page number 21.
And the lands, both are different, my lord. The court had held that the boundaries are different. Para 11.
Para 8, my lord, last.
Plaintiff asked the defendant to make a partition of the suit land in terms with the legitimate say of the plaintiff and then by submitting a joint petition there, the defendant is to the plaintiff. So what is the share of the plaintiff?
Here, my lord, plaintiff number 1 has 1 kata 8.45 lecture. Plaintiff number 2 is entitled to 8.12 lectures.
Where are you saying from?
In a written statement, ma'am.
I'm not doing, you have not given evidence.
Yes.
So
But it's on
without
the matter of
evidence,
record, my lord.
there's no
Matter of
evidence.
record.
Huh?
Matter of record, my lord, everything.
What? You have not given
Yes,
evidence.
we are, my lord, only limited to the pleadings, ma'am.
So pleading is not proof.
But that is their case also, my lord. My lord, as per Islamic
Where is
law,
their case in the plain to the effect?
my lord.
Where is their case in the plain to the effect?
Because they have, my lord,
Isn't it the finding of the fact of both the courts below that they are entitled to 2 kathas?
yes.
Then?
Yes. That 2 kathas will include the shares of the sisters,
Huh?
which they have made pro forma defendants, my lord. That we have admitted, that including the shares of the sisters, my lord, they are entitled to 2 kathas of land. But, my lord, where is that land? Because we are also admittedly, we are also Pattata. They have admitted him.
So what is
Within
the
a-
direction passed by the trial court?
Trial court, my lord, is a page number 50. Last paragraph.
Entitled to class possession after partition by evicting the defendant's block.
Lordship permits me, as regards what they have said, the sisters of mine, what they have their share also includes the two cutters. In our plaint, in para 12, we have stated that they have relinquished their share. In para 12, in our plaint, we have said the pro forma defendant, our sisters, have relinquished their share.
So therefore you are entitled
It
to.
was their two cutters. That is at para 12.
Fine.
Mother,
And it is a finding of fact, no case.
But my lord, at least in a suit for partition, at least in a my lord, patta, my lord, common patta.
Go there,
The
you,
court-
you go there before that. They are entitled to two kathas.
Yes,
They say
yes.
that the performer defendants have already left out, given up their share. So their share, you also admit, their share along with
Yes.
the performer defendants is two kathas.
Two kathas.
You also admit. So therefore, now the question is, you are entitled to some,
Yes.
so therefore you go and fight it out. They are entitled to two kathas, you also admit. Where do they get it? Let the deputy commissioner decide.
Yes, my lord, in the decree, the court ought to have declared the shares of the other interested parties as well, ma'am.
Why?
But as per order 20, ma'am. The decree ought to have contained the shares. of the-
So their right is there for two kathas the court had passed.
Yes.
Saying that go for partition,
Yes,
declaring their rights of two
Yes,
kathas.
yes.
Go there. You have your right. The court could not adjudicate
Yes,
because
no
you have to
demarcation
prove
was
it.
done. Yes.
If it is a joint person,
Yes.
you see, both of you are not brother sisters. So therefore, in that particular patta, you are to, he is to get two kathas, you will get it, take out two kathas from there.
Yes.
And if
But
that will be the preliminary decree, and thereafter you will get the khas possession. Then what is wrong?
Our only grievance is that, my lord, what they are pointing out is the land which we are in possession, ma'am.
That is to be decided by
Yes,
the
it's a preliminary
partition.
decree, but that could have been
The
done.
court did not say that. Did the court say it? Entitled to partition of the
court simply
Schedule
said that
B
they are
land,
entitled to the
B1 with the Schedule A land by creation of a separate DAG, according the issue of precept to the concerned imam through partition of the BU land in favor of the plaintiff by creating a separate DAG. Let us see the Schedule B land.
Page number 24.
Now you are in possession of this Schedule B1.
no.
Then how can the court give you, the court could have at least given you only two kathas of land
Two kathas, without the boundaries.
without the boundaries. But how does it mark to two kathas?
My lord, your lordship will find in the schedule land B1, your lordship will find a plot of land measuring two kathas, such and such covered by.
Within the following boundaries.
My lord.
How can you, if you are not in possession, how can they give you? If you are asking for partition,
Because
then
we have paid for khas position also.
That will be determined.
therefore it says, therefore the second portion again comes in, see, plaintiffs are entitled to khas possession of area after partition.
After
So don't you think these two appears to be wrong?
that aspect of the matter.
Otherwise, the court could have very well said that, okay, partition, everything done, take over the possession B1. But on one hand, the court sent it for partition
The
and
plaintiff
thereupon
are entitled
against
to
us.
khas position of B1 schedule.
Would have simply
Direction.
said that if
The court held that the plaintiff are entitled to khas position of B1 schedule and after creation of evicting the defendant therefrom.
No, are entitled to khas possession of B1 land after partition. After partition, by evicting the defendant. So
Well,
after partition, you will get B1. But partition, how can the B1 be specified?
If I am not in possession.
Unless it says that, okay, B1 is already there. If you are not in possession, if you were in possession, very well, one could have said so.
Because the court held entitled to khas position. That in the order of the
court
trial
ought to
court.
have said that they are entitled to only two kathas of land, we are entitled to our land, 1 bighas of land. So regarding the boundaries, my lord, without ascertaining,
Can the deputy commissioner decide that whether who is in
No, how do you take care of that decree? Because B1 has boundaries.
boundary?
We do one thing. We admit it. Admit and have it next week and finish it off. Because not necessary. I will exercise 4133 and say that it will be, they are entitled to these two kathas and the partition will be carried out by taking out from
My lord,
there.
your lordship, that much.
Happy both sides.
My lord, my lord.
He also gets his admission.
My lord. My lord.
Third, Mr. Esdas, the learned counsel appearing on behalf of the appellant, Mr. P.K. Roy Chaudhary, the learned counsel appears on behalf of
One
the
and two,
respondent numbers
1 and 2.
1 and 2. Full stop. And anybody, performer?
No.
Full stop. Taking into account the issue involved in the instant proceedings, it has been submitted by the learned counsel for the parties that the presence of the respondent numbers in the instant appeal proceeding, the presence of the respondent numbers, performer respondents would not, defendants would not be necessary. Full stop. Taking into account the above, full stop. Extra copy of the memo of appeal be served upon Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the respondents, number 1 and 2. Full stop. This is an appeal filed under section 100 of the Code of Civil Procedure 1908. Whereby thereby challenging the judgment and all decree dated 5/10/2024 passed in title appeal number 5/2021. Full stop. The instant appeal is being filed, the instant appeal is admitted by formulating the following substantial question of law. Full stop. Whether the learned first appellate or learned courts below were justified in passing a decree for partition of the, now, whether the learned first appellate courts below were justified after coming to a satisfaction that the plaintiffs are entitled to 2 kathas of land out of the Schedule A land to declare specifically the right, title and interest over the B1 schedule land without affecting partition. Taking into account the issue, the substantial question of law. Now, full stop. Next. It has been submitted by the learned counsels appearing on both the parties that the plaintiff herein would be entitled to 2 kathas of land. The plaintiff along with the performer defendants would be entitled to 2 kathas of land. And there being no dispute to that entitlement, comma, but without ascertaining the boundaries by way of partition, the suit premise, the decree so passed may not be proper, comma. This court is of the opinion that the records of the trial court as well as the first appellate court would not be essential till the next date. And that this court would consider calling for the records on the next date only. First, list the matter on date? 27? Okay.
Third, my lord.
Today, on 2nd of June 2025 at 2 p.m.
the IML.
for final disposal. What is it? For final disposal,
I don't know.
Stay matter, item 34.
What is this?
In this case, Lordship, petitioner's cross of PWs was closed, Lordship. Against that order, the petitioner is before this court.
Where? Where is the order?
Lordship, the original copy is page 59 and the typed copy is at page.
Both the parties are represented by the party eleven counsel. The newly pleaded so have filed wakalatnama and also paid time to file WSA. Defendant A is absent without any steps and so and so. He failed to submit the survey of the order. But which order are you serving?
Lordship, I am challenging the, before that, 6/3/2018.
Page? Both the parties are represented, plaintiff so and so and filed seeking adjournment for cross survey of the PW. PW1 is a government employee and could not get leave.
Lordship,
Seeing the plaintiff took two adjournments on the same ground on earlier occasion, hence my considered opinion. It is not satisfactory, hence the petition is rejected. Cross of PW is closed. Then,
against this order, Lordship, this CRPIO was filed, Lordship. While issuing notice, stay was granted, Lordship. And the respondent appeared, but some of the respondent did not appear, Lordship.
now newly implemented legal heirs of different numbers have been, they are going to file written statement.
Yes, Lordship, in the trial court, Lordship.
Oh.
In the trial court. And here, Lordship, I have later on filed an IA to incorporate the name of the legal heirs. And accordingly, they are implemented as 2.1 to 2.5, Lordship.
No, it's okay. That has been allowed.
Yes, Lordship.
Now the question is,
They are going to file written statement. Again, Lordship, the cross of PW will file.
Lordship, I am appearing for respondent number 3 on behalf of Bishina. He has already expired, Lordship. We have the date certificate.
who?
Respondent number 3 in this petition, Lordship. Until now.
We're paying for dead people.
No, we have already submitted Wakalatnama in 2019, Lordship. Thereafter, he expired.
Alatnama has been given to you in 19. You were not there in
And
He
Anil,
had
the
expired in
lawyer
2020,
profession in 19.
Lordship, Anil Chandra Nath is pro forma in my suit, Lordship. Anil Chandra Nath is pro forma in my suit, Lordship. Page 10, annexure 1. Main defendant is Aliul Islam, who is respondent number 1.
Anil Chandranath is performer.
Yes, Lordship. On
You are
J-
the plaintiff.
Yes, Lordship.
No.
Plaintiff.
You're plaintiff?
Yes, I am plaintiff.
Okay, your plaintiff evidence is closed.
Closed.
And what happened to the PW? Struck off.
No, Lordship, only PW are closed. Cross of PWs are closed, Lordship. We have filed our evidence in chief.
So cross of PWs are closed. You are the defendants.
I am the plaintiff, Lordship. My
You should
PW.
be happy.
No, Lordship, I cannot reduce evidence. My evidence,
No,
Due to
no,
my
cross
fault-
of PW is closed.
Lordship, due to my fault, my evidences were closed, Lordship.
The cross of PW is closed.
Lordship,
Then,
that will affect me, Lordship, as because the plaintiff is not present before the court, Lordship. Only evidence in chief was adduced, Lordship.
so the
He-
order is wrong.
Yes, Lordship.
And this judge must have written it later on, the cross.
Strike out the name of respondent number 3 and 4, Lordship. They are pro forma in the title suit.
And who appears for 2125?
I for 2-1 and 2-2. 2-1,
21225.
not for the other.
Why?
Yes, some technical.
Hello, we don't require that. So you want setting aside this order,
Lordship, 6-3, Lord.
6-3. And then fix it for,
Lordship, I will, Lordship, I will come for cross-examination by the defendants, Lordship.
fixing a date.
Lordship.
for your appearance for cross.
Lordship.
You have already adduced the evidence of two.
Yes,
How many
Lordship.
witnesses you have?
PW one is a government employee, it reflected here.
Now he must have retired.
He is 37 years in the year 2019.
So how many witnesses were there?
Lordship, total number of witnesses, I am not aware, Lordship, but PW one was about to be crossed by the defendant.
Madam, you cannot come half-cooked stories before us. You have to come up with full. You have to give me the details. You cannot come up with this, that how many witnesses are there, I don't know. If you don't know, I dismiss your petition.
It reflects that PW
It
one.
seems the petitioner counsel is not interested. Heard Mr. R. Chaudhary, learned counsel appearing on behalf of the petitioner. Full stop. None appears on behalf of the respondent number one. Full stop. Mr. So-and-so appears for the respondent number 1 and 2. Two, 1 and 2, 2. Full stop. None has appeared on behalf of the respondent number 2, 3, 2, 4 and 2, 5. Mr. S.K. Poddar submits that respondent number 3 had expired. Full stop. None appears for the respondent number 4. Full stop. It has been brought to the notice of the court that the respondent number 3 and respondent number 4 are performer defendants to the suit. And as such, the question of substitution on non-appearance to the instant proceedings would have no relevance. Full stop. It is further seen that the interest of the original respondent number 2 is duly represented by the respondent numbers 2, 1 and 2, 2. Full stop. Accordingly, this court takes up the instant proceedings for disposal at this stage. Full stop. The petitioner herein have assailed the order dated 6/3/2018, whereby the learned court of the Munsif, North Salma, Obhayapuri, had rejected the plaintiffs, had rejected the petitioners, have closed the evidence of the plaintiff and fixed 21/3/2018 for the chief of the defendants. Full stop. It is further taken note of. This court have inquired with the learned counsel appearing on behalf of the petitioner as to how many witnesses have been examined by the plaintiff. Has the plaintiff examined? Full stop. The learned counsel submit that she is not aware as to how many witnesses the plaintiffs had filed their examination in chief. Full stop. It appears that the plaintiff is not interested in the instant proceedings, and as such, proper instructions have not been given. Under such circumstances, the question of exercising the summary jurisdiction of this court does not arise, for which the instant petition stands dismissed. The interim order passed earlier stands vacated, and taking into account that the parties are duly represented, they are directed to appear before the learned court of the Munsif, North Salman, Abhayapuri, on 23rd of June 2025 for further proceedings of the proceeding.
35.
Okay, please, Your Lordship. Hearing your lordship, the office note dated 5/1/22 says that the respondents have received notice by register post and white note, office note dated 6/8/24.
What are you challenging?
Yeah, I am challenging your lordship. I filed my written statement. Initially, they filed a claim petition under MBH, your lordship, implementing only the employer of the deceased. Subsequently, they amended the petition and they implemented me. And notice was deemed to be served.
Mr. Counsel, what are you challenging? Tell me.
The order dated Annexure 8, Your Lordship,
Page
order dated, page,
3/1,
27.
2020.
yes, Your Lordship.
In view of the petition number so-and-so seeking time to produce evidence witnesses by the claimant list on so-and-so for cross-examination of the
Next
claimant
part.
witness.
Uh.
Written statement submitted by the opposite is not
So
accepted.
the
and
page
the
of.
stage of submission is over.
is over.
So this is it.
This, is-
Who are you?
I have been subsequently implemented as opposite party number 2.
Who are you? This
I-
is an MSC
I was
proceeding.
the owner of the vehicle, which accident took place in 2014, and I have already sold my vehicle in 2008. So I have stated everything, I have filed my written statement, but that was not accepted as the time was over, Your Lordship.
What
But
about the service upon the respondent?
respondent, Your Lordship, kindly see the office note dated 5/1/22. It has also been reflected in the order dated 10/1/22. Reveals that AD card in respondent number 1 to 3 received bearing their thumb impression. Whether respondent have 5 Okaratama registered to verify. Then
Did
wait
state-
subsequent note 6/8/24. Notice by register board received, we duly served, but by usual course, process server report is yet to be received.
Where is your petition to accept the written statement?
Your Lordship,
Where is your petition to accept the written statement?
after written statement is annexure 7, page 33.
Ah.
Your Lordship. Page 33. Annexure 7. This is my written statement filed on 3/1/2020, Your Lordship. Yes, on the same day, when annexure 8, that was not accepted, Your Lordship. Thereafter, I also filed petition on the same day later on to vacate the ex parte order and allow me to file the written statement. Accept my written statement, Your Lordship. That was
Heard, Mr.
R. Muthunder, Your Lordship.
And so the learning counsel appearing on behalf of the petitioner, full stop. The supervisory jurisdiction of this court, no one has appeared on behalf of the respondents on call, full stop. The supervisory jurisdiction of this court has been filed, have been invoked to challenge the order dated 3/1/2020, passed by the learned member MACT Karimganj, whereby the written statement submitted by the petitioner was not accepted as the stage of submission of the written statement was over. Full stop. The learned counsel submitted that along with the written statement, the petitioner had also filed an application for vacating the ex parte against the petitioner and to accept the written statement, which have been which was not at all taken into consideration while passing the order dated 3/1/2020. The learned counsel further submitted that in terms with orders 9 rule 7 of the code, when such an application is being filed, that too on an affidavit, the learned trial court ought to have duly considered before passing the order dated 3/1/2010. Full stop. Taking into account the above, and this court having taken into account the above aspect, is of the opinion that the learned trial court, learned court of the learned member Motor Accidents Claims Tribunal, Karimganj, had failed to exercise his jurisdiction in the manner envisaged in the law by not considering the application so filed, which was registered as petition number 8.
Your Lordship,
Petitioner number,
petition number.
which was filed along with the written statement.
Subsequently, it is
Full stop.
131, Your Lordship.
Petition number 131, along with the written statement. Full stop. Consequently, this court sets aside the order dated 3/1/2020. Full stop. Further taking into account that not taking further taking into account the contents of the written statement, comma, no, further, taking into account the above, this court set aside and quashed, full stop. This court further directs the learned member Motor Accidents Claims Tribunal, Karimganj, to consider the petition number 131 oblique 131, so filed by the petitioner, and as to whether the said amounts to a good cause, and as to whether a good cause is shown in the said petition, for so as to permit the petitioner, who is the defendant opposite party in the said proceedings, to file the written statement. Full stop. Accordingly, the instant petition stands disposed of. The petitioner herein is directed to appear before the learned member Motor Accidents Claims Tribunal. Etu naam to ki asil etu? On such and such year, on 23rd of June 2025, for further proceedings of the suit. Interim orders, if any, stands vacant.
36.
Much obliged.
Mr. Sahiwala, in those cases, inform the other side, I'm fixing the matter on 16th of June before, because I'm restoring. So if I don't fix a date, then they would be. So I'm fixing it on 16th of June for appearance of both the parties. Huh? Inform Mr. Bikus. Yes, who wants to go from where?
Transfer application, my lord. Well, a diverse suit is filed before the Court of Family, Principal Judge, Family Court number 3, Kamrup Metro, my lord. Wife belongs from Udalguri, my lord. She has filed a case of domestic violence at Udalguri. Now she is seeking transfer of this matter.
Not sure. Actually, the one, there is discussion is going on for settlement actually. From with the petitioner and the respondent.
Right. Now, what does the petitioner do?
The petitioner do actually, I have no instruction, Lakshmi. I have no instruction, Lakshmi, actually, for that.
You don't know.
The petitioner has
The matter has been coming for a long time. Then you don't know.
Yes, but they are.
What does the
divorced
petitioner do?
He is unemployed, my lord.
Housewife,
Housewife.
staying with,
Now staying with his her mother. At
Mother.
Udalguri.
okay, transfer. You will go and appear before the before the learned court of the district judge, Udalguri,
Udalguri, my lord.
on 27th of June 2025, on which you are going to file the written statement.
Right.
Allowed.
Deeply obliged.
38.
There are two wills, my lord, they file in two matters, my lord. So we file a petition, my lord, for sending both the wills to the expert, my lord, to compare a signature, my lord, with the other original signature, my lord, which was rejected here, my lord. Page 45.
Page 45. What is wrong with that order?
So, my lord, both the wills, you can also see the, my lord, both the signatures are different.
No, no, understood. But
Yeah.
the fact remains that you have not given where the original signatures are.
Original, my lord, if it is ours, my
No,
lord,
no,
we can
it has
see
to be compared with what?
Yes, my lord, that there, my lord.
That is not there. That is not there before the trial court. That is why the order is being passed. At least read the last paragraph of page 45.
So we can file a place picture, my lord.
should have filed a fresh petition out there asking what, this is, how can we exercise 227 here?
No, my lord, this, my lord, liberty will be granted to me, my lord. So
Huh?
I have a press petition because I have admitted signature, my lord, deed is there, my lord.
Heard Mr. J. N. Savile, the learned counsel assisted by so-and-so and Mr. So-and-so appears on behalf of the respondent. Full-stop. The learned counsel, senior counsel submits that taking into account the order dated 5/1/2024 and the fact that the petitioner did not place before the learned trial court as to what were the admitted signatures, comma, he may be permitted to withdraw the instant petition with the liberty to file a fresh petition, placing the placing more details as to which would be the admitted signatures with which the signature on the will dated
Wills, my lord, two wills, my lord, dated,
2/6/2008 and 12/8/2008 can be compared. Full stop. Taking into account the above, the instant proceedings stands closed on withdrawal. Full stop. The interim order passed on 13/5/2024 is vacated. Full stop. The withdrawal of the instant petition shall not preclude the petitioner from filing appropriate application before the court of the learned additional district judge, FTC at Silchar, by providing the admitted signatures with which the wills dated 2/6/2008 and 12/8 prejudice the petitioner to file an application providing providing the details of the admitted signatures with which the will dated 2/6/2008 and 12/8/2008 can be compared by the FSL. Full stop. Taking into account both the parties are duly represented, they are directed to appear before the learned trial court, before the court of so-and-so on 23rd of June 2025 for further proceedings of the probate proceedings. Of proceedings of test suit number 5 of 2017.
39,
So the petitioner is the liberty so given to file the application by the petitioner is to be exercised on the next date so fixed here in number. Yes, Mr. Sigdar.
My lord, here in this case, my lord, by order dated 21/10/2020, notice was issued and there is a stay against the interim order.
Huh?
There is a stay also.
Stay?
It was granted by order dated
Steps be
21/10.
taken by way of considering the submission of so-and-so, the impugn order dated passed by the learned civil judge, stayed.
My lord.
What is that order?
My lord, order is at page 99. The account of the case is that, my lord, we file a title suit, right, claiming right titles and injunction also. In that case, there was this initially stay.
What is wrong with this order?
My lord. In my, the case is out of, my lord, my title suit.
Huh?
In my title suit, I filed an injunction, there was injunction. Then they have filed an appeal, misappeal, that injunction was vacated. Then I approved this on court, there is a stay. And then he has also filed a injunction petition in a counterclaim. And that counterclaim was rejected. Then they filed a misappeal and their appeal was allowed by this order. My lord, status is maintained because on the strength of vacation of, on the vacation of this order, my lord, interim order passed by the trial court,
the status quo is maintained and status quo by the strength of the status quo. they
No,
will dispose it, my lord.
the order page 104 says, according concluded that the order is not proper and order of rejecting the injunction is set aside. Since the position of the suit land, which is a pond, is used by both the parties as it appears, it will be appropriate that an order of status quo is passed by preserving the nature and character of the suit property. According, both the parties are directed to maintain status quo. The suit length of the suit length till the disposal of title, it is made clear that the order of status quo is binding upon both the parties. What is wrong
Well,
with that?
My lord, on the strength of status quo, my lord, pond is of both the parties. But they are claiming that my share of pond, I have allegedly sold to them. That is their claim.
So
That is,
status quo has been directed to be
my
maintained.
lord, on the strength of status quo, they are trying to dispose me, my lord.
How?
Yes, they are not entering us to, they are not entering us to enter into the pond. My lord, by the status quo, my lord, they are occupying everything, my lord. They are
What do you want?
occupying the
What
pond, my
order
lord.
should I pass?
My lord,
You have got that status quo vacated by getting a stay here. As of now, there is no status. As of now, they can take over the entire possession and throw you out. Isn't it?
yes, my lord, because of the status quo, they are trying to throw us out,
No. Because of this stay,
my lord.
you got a stay of that order. And therefore, there is no status quo. This is why I'm shocked. Why
My
you
lord.
have taken the stay?
Status quo order has been
Because the
stayed
status quo directing
because
both the
time
parties to
court
maintain.
has granted us in our favor. Injunction was given in our favor
Right?
by the trial court.
Injunction to the what?
My lord, in my injunction petition, the trial court has granted injunction. Their injunction petition was rejected.
No, what is your injunction order in your opinion?
Injunction, my injunction is that they are restraining us to enter into the pond. And I have given some fencing, and that fencing was broken by them.
So what is your injunction order passed by the trial?
My lord, my injunction order, my lord, is that they cannot prohibit us to enter into the pond, my lord. And they are prohibiting us to enter into the pond, and they are occupying, they are enjoying the pond, my lord.
So now they can do anything. The moment you have got the stay.
My lord, even the stay
Because
order,
you see, the problem which has happened, the order of the trial court no longer remains in view of the appellate order. It has lost its existence.
yes, my lord.
So what happens is, with the stay being granted to the appellate court order, there is no injunction of either side.
Yes. Because of the stay of this court, my lord,
You are using it.
they are, no, we are not losing, my lord. Status quo is not there. Status quo order has been suspended. So, my lord, the interim order granted by the injunction granted by the trial court, that will prevail, my lord.
You cannot. That order is no longer there. Because there is already a merger. Isn't it?
My lord, there is another CRP, my lord, because two CRP, my lord. One, against the my.
Okay, what is the
interim-
number?
My lord, that is, I have annexed in this petition also. At page 89, my lord, CRP IO number 32624.
List the instant application, instant proceedings along with CRP number 326/2024 on 4th of June 2025. Published.
40,
Prayer for stay of the suit was rejected.
Huh?
A prayer for stay of the suit was rejected.
Pray for?
Stay of the suit, my lord. What happened, my lord? There are two suits, my lord.
Then,
My lord, already there is a earlier order that both there are two suits, my lord. At page 48 operating part, my lord, that at the time of argument, both the suits will be heard together, my lord.
where?
Page 43, my lord. Paragraph 10, my lord. Relevant portion.
What is the other stage of the suit?
My lord, one is at the argument, other is at the PW evidence of plaintiff witness, my lord.
And why the other suit has not proceeded?
My lord, in between, there are some amendments in the plaint and that amendment was there, my lord. That's why the other suit has not, some delayed, my lord. And then
Then,
the service of summon and all this are there. my lord.
huh? Now what has happened?
Now, my lord, since the one of the suit has reached the stage of argument, the petitioner has filed the petition that since there is order, so stay this suit till the other suit reaches the stage of argument. That petition was rejected.
Rightly so. Why?
My lord, there are two suits filed by the plaintiff, my lord. I am the defendant in
It
title.
is argument is not concerned. Argument the court should proceed. A trial should be, which is the suit? Title suit 25 is earlier or the later?
But both are filed on the same date, my lord.
No, but 25 is the earlier, previously instituted. 20
My
So
lord, the filing date is same, my lord. And my
Oh.
lord, in both the cases, the plaintiff is same.
previously instituted is the number. Then how do you state the previous
My
order?
lord, the date of filing is same. Both are filed on, my lord, 6/9/2018, my lord.
No case. What has happened in the meantime? 7 months have, what, 3 and 5, 8 months have gone. What has happened to the other earlier suit?
My lord, I have asked, but he is not able to confirm what
No,
is the
we
status.
dismiss it, then your things will come in.
But,
Heard
my lord,
Mr.
the
A.K.
prayer-
Gupta, the learned counsel appearing on behalf of the petitioner. Pusta. The present proceedings have been initiated challenging the order dated 9/9/2024 passed entitled suit number 25/2018, whereby the learned trial court was of the opinion that taking into account the title suit number 25/2018 is at the stage of argument and title suit number 26/2018 is still at the stage of in pleading of the defendants, was of the opinion that the said title suit of 25/2026 be proceeded with the arguments. Pusto. A petition was filed for taking up both for deferring the title suit number 25/2018 till title suit number 26/2018 reaches the stage of arguments. The said petition was rejected and it is under such circumstances the present proceedings have been filed. Full stop. This court have inquired with Mr. A.K. Gupta as to what is the present stage of title suit number 25/26/2018, who submits that still it at the stage of plaintiff evidence. Considering the above, this court is of the opinion that there is no good grounds for exercising the supervisory jurisdiction of this court in the present proceedings in against the order dated 9/9/2024, for which the instant petition stands dismissed. The interim order passed on 11/11/2024 stands vacated, and the petitioner is directed to appear before the learned trial court on 23rd of June 2025. The learned trial court, that is the court of the the learned trial court, that is the court of the Civil Judge Junior Division, Rongia at Kamrup, shall proceed with the said suit, title suit number 20, that is title suit number 25/2018, in accordance with law. Also, however, taking into account that the respondents are not represented in the present proceeding, due notice also shall be given to the said respondents before proceeding with the arguments of the said suit. Any extension of interim order?
In item 29.
29, na?
Yes,
Oh, this matter. Oh, this matter, na? I passed an order that why there is such a long stay, such a long order time is given, na? Okay, we do one thing. This 29, we fix it on next week. For it. Is the service complete?
No, Lordship.
You have
Dusty service we
done
did.
a dusty service,
Yes, Lordship, they have evaded the.
but have you filed the affidavit? Dusty service, you have filed the affidavit. Okay. Then we do one thing, we give it for admission on 6th of June.
Yes.
List the matter on 6th of June, 2025. In the meantime, the interim order passed in the earlier shall continue till then. Anything else? Any interim orders to be extended?
Lordship, in orders item number 41,
40,
1,
41.
supplementary.
Service is not complete. Is an interim order?
Stay in the state, it is extended till next day.
The interim order, taking into account that the service is not complete, list the interlocutory application again on 23rd of June 2025. Interim order passed earlier shall continue till then.
Lordship, item number 30. The
Please,
suit was stayed and I filed this affidavit of service. We have delivered the copy of the notice along with the copy of the.
Service is
application.
there. You have effected.
Yes, I've effected and I have filed my
Okay.
service.
It has been
affidavit.
submitted that an affidavit of service have been duly filed. You have brought it today.
It is in the record, Lordship.
Fine. Good. So taking into account the above, the instant matter be listed again on 9th of June 2025. Interim order passed earlier shall continue till then
Pass on
for
that.
admission. Huh? Anything else? Anybody else? PRP. Preventing somebody has not taken steps. Oh, 17%. 17%.
Without
You are appearing?
item number 20.
Yes.
Order may be passed for issue of notice.
Just let me have a look at 17. Okay, where is Mr. SP Chaudhary? And appears on behalf of the devotion, list the matter again on 9th of June 2025.
Item number
9th,
20.
not, 11th of. Item number 20, what is this? 20. What is this?
The-
Service complete.
No service may be taken, another chance may be taken.
Item number 20,
20.
20 na?
20. 20.
এই গোটেইকেইটা ডেট দি দিবচোন ঠিক আছে ডেট দি ইণ্টাৰিম অৰ্ডাৰবোৰ য'ত আছে এক্সটেণ্ড কৰি দিব টিল দ্য নেক্সট ডেট
Issue notice. Issue notice to the respondent.
য'ত ইণ্টাৰিম অৰ্ডাৰ নাই তাত ইণ্টাৰিম অৰ্ডাৰ নিদিব আৰু এইটো সেইটো ইয়াত দিব এইবোৰ চব লেট নটিচ হৈ আছে এইটো আইটেম নম্বৰ 20 when do you want it
20.
when do you want it
First of June.
item number 20 will be listed on 10th of June 2025 এইটো সাৰ্ভিসটো কিয় কাৰণে হোৱা নাই এইটো গণ্ডগোলটো
Not
কি
this one.
হা
This has not taken.
সাৰ্ভিসটো কি গণ্ডগোল হৈ আছে চাই ল'বচোন এইটো লেট ফৰ অৰ্ডাৰ্ছ বুলি লিখা হয় ন আইটেম নম্বৰ 22 আৰু এইটো CRPIO এইটো 28 টো কি
IA was allowed for condonate delay. At the first date, the adjournment was taken. Hence, notice was not issued.
to দিব হা this matter for motion on a Friday good. This is to come for motion. Notice has not been issued. On which take it. Anything more? No.